I'd like to call the meeting to order. This regularly scheduled meeting of the Board of Architectural and Engineering Examiners is taking place in 308 Feveringill Hall at Union University in Nashville, Tennessee. And notice of this board meeting was posted on the board website on September 25th, 2017. And if we have any guests here, I would like for them to sign in, please. We'll have a roll call.
Susan Ballard. Robert Campbell.
Present.
Philip Lim.
Here.
Blair Parker.
Here.
Brian Tibbs. Rick Thompson.
Here.
Frank Waxter.
Here.
Kathy Ware.
Here.
Ricky Bersad.
Here.
Stephen King.
Here.
You have a quorum.
I'd like to acknowledge our guests. If you would, stand up and let us know who you are. But before we do that, I'd like to turn it over for a second to Senior Associate Dean Art Oberholzer.
Thank you, Mr. Chairman. Welcome, ladies and gentlemen. I know many of you, but I did want to tell the whole board how pleased Vanderbilt University and the School of Engineering are to have you with us. In our own mission, the School of Engineering, to help prepare what we hope will be part of the next generation of highly professional and ethical engineering leaders. We value consider ourselves your partners forward. And finally, as a professional engineer myself, a long-standing and a citizen of this state, I thank you all for what you do for our professions and for our citizens. Thank you.
Right.
Thank you for your hospitality.
Thank you. We hope you come back. I'm sorry it's a little cozy in here. We have bigger rooms, but they're full of glasses.
Okay. Now, if our guests, if you would just go around the room, stand up and let us know who you are.
Casey Anderson, I'm the Executive Director of the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers.
Don Baltimore, representing Tennessee IDEA, which is the Interior Designers Association.
Terrence Hill, I'm a consultant with Kinley Moore.
I'm Mickey Sullivan. I'm with ACC on the State Board of Directors, and I work at Gresham Smith and Partners.
Steve Fields. I work with Stantec here in town and with ACC as well. I'm Chris Dwelney. I work at Lipscomb University, and I'm here to observe for ASCE Nashville Branch Tennessee section.
I'm Douglas Bell, work for TTL here in Nashville, and I'm on one of the ACEC committees, the Business Practice Committee.
I'm Chad Polk, an architect here in Nashville, secretary for the AIA Tennessee.
Good morning, I'm Ashley Case, Executive Vice President of AIA Tennessee Architects Professional Association.
My name is Fuller Hannon. I'm an associate architect in Nashville, representing the Emerging Professional Committee of Middle Tennessee.
Okay, thank you. Do we have any announcements?
Well, we do have some appointment announcements to make. I think everyone's received their letters, so I think it's common knowledge at this point that Laura Rainbold has not been reappointed to the board, and Alton Heathcote has been appointed to serve in that position. Also, Ricky Bersai has been appointed to serve in the West Tennessee engineer position, which is currently occupied by Mr. Lim. So we still have two vacancies, our public member, and now, since Ricky's moved to Philip's position, our West Tennessee associate engineer member position is vacant as well. So two vacant positions currently. But those appointments are still in process at this point. They have to, the governor's office has to receive the oath of office. They have to transmit it to us and so forth. So those are still pending, but I just wanted to make everyone aware of those appointments.
Okay. Congratulations, Ricky. You not only moved to a different position, but 3 more years, I guess.
I think it's 4.
4. Why did you say it that way?
If I'm doing my numbers right.
Yeah. Okay. Good. That's great. That's great.
Stay in line.
Yeah, that's right.
Has everybody had a chance to review the agenda? Does anybody want to move anything around by any chance? There not being any changes to be made, I'll open up our open forum for public comment. If you have something that you would like to bring to the board, please stand up. Please let us know who you are and who you represent. And just for time purposes, we're going to limit the amount of time that you spend saying something if it goes on and on. So, so
Every time you get out.
you know, I'm thinking 5 minutes max, probably less if you keep saying the same thing. But anyway, please go ahead with it.
I appreciate it. Again, like I said, my name is Terrence Hill. I'm with Finley Warren Associates here in Nashville. So I'm a transportation engineer. Primarily, I do signal timing and signal design. I just want to briefly tell my story real quick. I'm a professional engineer, but I'm currently not licensed here in the state of Tennessee. I'm licensed in Virginia and Georgia. And my story briefly is I'm from the Atlanta area originally. My undergrad degree is actually in civil engineering technology. And unfortunately, the rules as they are currently do not allow me to be licensed here in the state of Tennessee. Like I said, my undergrad in civil engineering technology. I worked for a couple years at a highway design firm in Atlanta before coming to University of Tennessee to get my master's degree, so I do have that. Since then, I worked at the Tennessee Department of Transportation for about 4 years, and then I made the transition about 4 years ago to Kimley Horn, where I currently work. Like I said, I wasn't able to take the test here in Tennessee. My application was basically denied. I was able to take it in Virginia, applied for reciprocity in the state of Georgia, and again, I am a licensed professional engineer, but unfortunately not in the state of Tennessee. Since I've been here, there have been 2 instances where the rules have kind of been bent a little bit. Back in 2008, anyone who had a master's degree and 4 years of experience were allowed to be a professional engineer. Unfortunately, my experience level at that time did not permit me to be that. Currently, there is a rule that allows someone with 20 years of experience to be a professional engineer. Again, I do not have that much experience right now, so I'm still unable to be licensed in the state of Tennessee in which I live. Moving forward, you know, whether or not I'll be able to be licensed can affect many things in my future. So I kind of just want to bring that to the board's attention. I know if you're all looking at decoupling, again, the law that was passed recently last year kind of brought this to light again. And so there are additional situations, you know, similar to mine out there where people who are qualified cannot, who do practice in the state but just cannot be licensed right now. So that's pretty much kind of what I just want to bring to the board's attention.
Okay, thank you.
I'm Mickey Sullivan, and today I'm representing ACC of Tennessee. I wanted to talk about an item that you do have on your agenda for later, which deals with qualification-based selection and the taking down of the FAQs from the website. I want to let you understand how we have dealt with the QBS process across the state. When we have situations where a state agency or a municipality we believe is not following the intent of the law, we've used ACEC as sort of clearinghouse to fill those requests, and those are done confidentially. Our executive director fields those, and then we'll make contact in sort of the spirit of education to the municipality or other agency that may be, we think, outside the bounds of the law. Usually, 90-some% of the time, that outreach and that educational effort pays off, and the agency who's intending to procure AE services does revise their solicitation process to become compliant with the law. And for the last several years, that's been pretty smooth. It's hasn't caused a lot of ruffled feathers. Hasn't put our members, our registrants, in any sort of dilemma as whether or not they should submit on a project or not. There are a few cases from time to time where we maybe are in a gray area and it's not abundantly clear maybe to us or to them if they're under the law or not. In those cases, the FAQs have provided some clarity for us and been very helpful. Again, and those are they were considered authoritative, and so gave ACC and executive director, something to point to in this educational process and say, this is what the law is saying we should do. Again, that helps the process. Now that the FAQs have been taken down, that authoritative reference is no longer available to us. And we're afraid that's going to be problematic. So I know there were probably good reasons for taking it down, but I guess I'm here to say let's get those back up as soon as we can, because I think it's pretty important that we have those to lean on. In the absence of that, and as everybody knows, the law is set up to so the enforcement's back on the registrant. And in the absence of the FAQs, in the absence of the ability of sort of clearinghouse agency like ACC or AIA, we're left with possibly a registrant turning in another registrant if they think there's been a violation, and try to get enforcement through that mechanism. That's not something any of us would relish doing, obviously. That is the way the law is written. So we would like to sort of come as far upstream as possible, use the educational approach rather than any other alternative, and deal with these exceptions when they come up in that manner. And it's essential that we have the FAQs at our disposal to be able to do that. So that's my appeal to the board, and I guess maybe the staff as well, that whatever reason there was to take those down, if we could get them back up as soon as possible, we would really, really appreciate it.
Thank you.
Steve Field is representing ACEC as well, and I kind of mirror what Mickey has said, but also, I guess in the absence of having those facts and authority, we need some guidance to give to the registrants on these different issues. And one of the things we wondered is, there's the ability to get the AG to give an opinion on the law and jurisdiction over this question, and wondering is that something that the board is able to take to the AG to get that opinion, and just I guess through the process and discussions later on, would like to know if that is something that the board is able or willing to use.
Stephen, what exactly is it that you're asking an opinion of? What is the thing?
The opinion of, does the board and the FAQs, should they be there for the use of us in these discussions with municipalities, and help the registrants understand the law and where we stand in procurement actions as to whether we should submit a proposal in those gray areas where it's not clear. Does that answer your question?
Not exactly.
Okay.
Typically, the Attorney General is going to interpret a rule. So what is the rule that you're looking for the AG to interpret?
Last week we had a session with representatives from the board staff, and some board members are there also. And I think that the insight I got during those discussions was that, and this is again around the FAQs and why they might have been taken down, there's maybe some question about who owns the statute, who owns the administration or enforcement of the statute. And so, and that may be complicating what our ability to have the FAQs at our disposal. So either, I think what Steve's saying is either we get an AG's opinion on the questions that the FAQ addresses, and then we could use an AG's opinion in lieu of FAQs, or we get the AG to deal with the issue of who does own the statute, or both.
Anyone else? Okay. All right. Yes, ma'am.
We have a representative from AIA Tennessee that would like to speak on pre-licensure titling if no one else is on this subject.
Yeah, if this is the appropriate time to do so. I'm Chad Polk, Secretary for AIA Tennessee. Just to give you a little background and history on this issue, back in, I guess it was 1999, when I was an associate member, an intern member of the AIA, people were receiving notifications in the mail that essentially saying, cease and desist from I guess, listing yourself as an intern architect in publications where firms were saying, hey, we want to welcome our new intern architect, Chad Polk, to our firm, and then that firm would receive a letter with a fine attached and ask, I think, even the recipient to, or the intern to actually pay a fine, and the firm to pay a fine, if I remember that correctly. Either way, the issue came up kind of in our state board at the time. I was the associate member on the state board, actually the first one at the time. And we came before this board at that time and argued for the term intern architect. Frankly, none of us liked it then, and we don't like it now because most people confuse the term intern as somebody that's still in school, and that's sort of the public perception. And frankly, that's why I think we're here today, because of the public perception of an intern being someone still working towards receiving their education. So we were successful at the time in the fact that intern was a qualifying term to the word architect. It was pretty understood as an intern, even though most people thought we were still in school, that you were not a registered architect by that qualifying term of intern. It was passed at the time, and I think it stood as a policy, I guess, for about 15 years or 16 years. And we just found out that had been essentially repealed in, I guess, December of 2015, and I don't think any of us even knew that had been repealed. So, so here we are today. The AIA National has come out with new proposed terms for an unlicensed professional, basically an unlicensed architect, someone with a degree from an accredited school of architecture. And those two terms are architectural associate and design professional. So we had our discussion at our state board the last meeting to kind of go over the pros and cons of supporting the position of National AIA, which we do. We stand by that support as a, I guess, a charter, chapter member of that national organization. However, we were concerned how that term would be administrated here at the state level in the licensing board. Currently, it's not addressed at all, except for the use of the word architect. That's what I understand by law. And there's a ton of research that was provided to us from the board, from the architecture group, and looking through it, it's not a simple matter, frankly. Across the country, there are a lot of varying opinions on what's acceptable, what's allowable, and so forth. So we'd like to engage in a conversation about that and see what the board feels. But at the same time, we'd like to have a little more time to go to our different areas around the state and get a little more feedback from what the state architects here, not just national, but what we feel to be the appropriate terms. We presented a document.
Just to, not to interrupt, but
Sure.
to kind of cut to the chase, are you recommending that the term architectural associate would be appropriate?
Well, we think there are issues with that. Frankly, I was looking through the Sophisticated Living magazine last night for Tennessee, and in there's an ad for a contractor who, on his advertisement, it was a full-page ad, by the way. It was design and construction and architectural design was listed at the bottom. Now, I'm to assume they're not architects, because otherwise they would have said architecture or architect, but they use the term architectural, which is sort of a vague term. It opens yourself to, interpretation. I still think it's misleading to the public, but is it protected? I think is more the question. And so that was one of the questions: is the term architectural associate a protected term, and is that even allowable by the board? The other things we thought would be qualifying terms, just like intern architect, something that would describe the situation as a graduate architect. That would be an allowable to our members, associate architect.
Well, let me stop you for a second.
Yeah.
Are you recommending that the architects on the board here spend more time and consideration?
I believe that's what we're asking, actually, yes.
Okay.
So,
I think you even said you guys want more time as well.
yeah, we'd like a little more time to present maybe a clear
Okay.
direction after looking at this sort of a holistically across the country. You know, we don't want to be in violation of other states by having our business cards say something that may not be allowed in those areas.
But presently there is no state
Well, I think it's
intern architect or anything
acceptable
else.
as intern architect. Most all of us, since it was approved at the time in '99.
But that's no longer.
But nobody knew that. Nobody's known that it hasn't been acceptable because, frankly, I don't recall it ever coming up in any of our chapter meetings or anything else. So everybody on the business cards typically have intern architect, and it's kind of understood in our professional
They shouldn't.
circles.
They shouldn't.
Whether they shouldn't or not, that's what people have done. So that's what I guess is been generally accepted, and that's what's going on now. And we're not receiving the letters where we're being told not to promote.
Thank you.
Okay.
Thank you.
The architectural group will
We'll give it
take
for
into consideration.
All right. Thank you very much. Appreciate it.
Any more? I think Robert has some abbreviated questions.
Pretty good. Mr. Hill, how many years did you say you had after your master's degree?
I had
Experience.
3 at the time.
How much?
3 at the time.
How many do you have now after your?
Oh, now 11.
11.
Yes.
Okay, thank you. In regard, this is for staff and attorneys, in regard to remind me, the prohibition against pricing where we used for the registrants, was that a rule or was that a policy? Yeah.
I'm sorry.
What was the question?
The prohibition that we had against when we came out a few years ago and said a registrant cannot use pricing. I mean, it's a rule. So a rule goes through a rulemaking process, which has been approved by the AG. We have a seals rule, or is it a law?
It's a rule.
So we have a seals rule that in that seals rule says what's acceptable and not acceptable to meet the intent of the seals. So my point is, I'm agreeing with what you're saying in that we have some guidance. When a rule's there, it goes through a regular process, and in our rules, there are typically some language that aid the registrant in the proper use of whatever that is. So, and I use seal as an example. It says you have to write something across the circumference, you have to do this, you have to do that. So it stands to reason from my way of looking at things logically that we should also have guidance for the registrants on this rule, which says you can't use pricing, and here's that guidance that we give you. So in response to your question, the actual rule did go in front of the AG because they have to approve that. Now the guidance or fleshing that out, I think we've had a semi-preliminary ruling at one time on one aspect of those FAQs, if I remember correctly, on the sealed envelope question, and I'm not sure it was a formal thing. But they have reviewed some of those, if my memory serves me right. We talked about that in the board meeting.
It was discussed with an attorney in the AG.
Okay, so I mean, I said
it was not a formal.
I didn't say formal. I said I used quotations, so I'm sorry that's not on the video. So again, I think that we have other rules that have gone through the proper process. We didn't do this in the dark. We did this in an open way through the process. They give our registrants guidance on what that rule means, and it gives them some basic do's and don'ts, and I don't understand why an FAQ or some other way to codify this would not also be there to be able to give our registrants guidance so that we can keep them from going down the wrong path. So anyway, that's my comment, and I just wanted to make sure that that was, I thought that was a rule, but I just wanted to make sure of that. Thank y'all.
Okay.
Was that semi-brief?
Semi. For you, it was extremely.
What's this? But they were important questions.
Yes, they were. If we had anybody come in the room that would like to make a public comment.
I would like to make a comment.
Okay.
My name is Fuller Hannon. I'm an associate member of the AIA. I am actually actively working towards my licensure, and I understand the responsibility and the duty that comes with calling oneself an architect. I'm pursuing my licensure for that reason, because I want to be able to call myself an architect free and clear, so to speak. I'm also a recession graduate, where I believe the word intern was muddied in the eyes of the public when a majority of graduates, regardless of the field of study, struggled to find full-time work. This led to an increase in internships as a means of filling the gap of unemployment, especially for younger professionals. In the time since I've been working, I've experienced this misunderstanding firsthand when I've had to explain further upon introducing myself that I'm in fact a graduate of a 5-year professional degree from a NAB accredited program. It's kind of a long, introduction. And I recently wrapped up a project in Scott County, Tennessee, a rural community with limited exposure to design as a tool for an improved quality of life. And interestingly, at the conclusion of the weekend charrette, in response to the question, what are the most influential careers in designing and promoting healthy communities, the youth participants identified architects at a 183% higher rate after participating in the weekend. I agree with the board that in the opinion that the name architect carries weight and responsibility, but I would also add that it also carries the power to expose people to ideas and solutions, and this is a decision that needs to be considered from both an internal and external perspective in order to sustain the practice. Thank you.
All right, thank you. You have one more? I think you came in late. If you would introduce yourself.
Sure will. I'm Shaman Jerry Allen, Big Pen. I had some complaints before this board.
I'm sorry. Don't want to stop you, but somebody's phone was going off, and I didn't catch your name.
Yeah, I'm sorry. And I didn't know it was taken care of.
I'm Shaman Jerry Allen, Big Pen. The August 12th, 2015 meeting, there were 2 of my complaints before this board, and the state's attorney general argued, and in my opinion reprehensibly, for this board not to hear it. There were several members of this board, I watched the recording of it, who seemed to be quite reasonable and willing to field those complaints. So I'm here today to ask you at your next November the 12th meeting to review those complaints on their merit. That matter, the civil litigation, that the state's attorney thought it would be wise to leave to one man, the judicial commissioner appointed, to determine the matters that are actually spelled out in the complaint, as opposed to this board of experts in the areas, and I'd like for them to see it. And I've called into the office to get each of y'all's names and contact information, and prior to that meeting, in addition to this file, which Mr. Cochran has, I will give you a very clear and succinct bullet point of each and every one of the allegations, because the state's attorney general, in arguing against you hearing it, distorted the facts, obfuscated, and they weren't clearly what I was alleging. I wasn't challenging the engineers' qualifications as experts. Both of them had amazing credentials. I was simply challenging the fact that those reports are fraudulent on their faces.
Okay, thank you.
Okay.
Do we have any other public comments? Okay, then I would say that our open forum and public comment period is closed. And the next thing we have on our
Wait.
Well, before you leave,
Sorry.
just let me give you this one thing, and this is, don't email us anything, because if we end up hearing this, we don't need any information beforehand to be able to, we hear it at this meeting. We don't hear it outside of this meeting. So if you email us the facts of the case, we recuse ourselves. So you're basically not going to have anybody to hear it if you email us whatever this thing, you understand what I'm saying?
Understood. I will send the outline to you.
Yeah,
and
and
Ms.
that, yes,
Francis.
send it to staff, because if we get information of stuff beforehand,
Okay.
we have to recuse it, because we're supposed to be unbiased with no preconceived or
Understood.
Okay, so please don't email us in.
I will not do that then.
Okay.
Could I ask you a question? When you have that hearing on the 12th of November,
Actually, we meet in December.
for whatever reason, I got off the website that the official review board was the 12th of November. If I got that wrong, I stand corrected. Am I prohibited from attending that meeting?
No, this is an open meeting.
When you do your reviews of complaints, am I prohibited from addressing the board in response to any arguments the state attorney may have?
I'll let them go through the process. They're a little bit more versed.
Typically, we present these anonymously to the board, so it would be best if you did not address the board. That way, it is an anonymous complaint, and there's no connection with you. In the event that anybody who should know you or be familiar with you want to respond.
I have no desire to present these complaints anonymously. In fact, I'll swear them with my name on
No,
them.
you would, but we, meaning the legal group, will present them to the board anonymously.
And you are with the Civil Rights Division of the State's Attorney General?
No.
This is the Architects and Engineers Board, where their attorney, we don't work with the AG at all.
Okay, but at the review board, somebody from the AG's office, the Civil Rights Division, will be present?
We don't have a
looking at a different board.
You may be on a different.
Well, no, I was looking at in order to identify the woman who I understood, I think we had that discussion, who was arguing against the board hearing my complaints on their merits. I understood that to be an attorney with the AG's office, the Civil Rights Division. That was actually,
If you can get with John Cothran, and we'll try to figure out kind of what that was, and if we can connect with someone at the AG's office as well to try to get you to their meeting, we can.
I truly have no interest in standing here when there is a review of these complaints, arguing with anybody in defense of the state's AG's office and what they actually did in this case.
Okay.
So.
But there's not anybody here from the AG's office.
Okay,
None of us.
well, I'm glad you cleared that up. So y'all are strictly legal counsel for the board. Okay, fantastic. Fantastic. All right, gentlemen, I will see y'all in December. 12, is that correct?
Yes, correct.
All right, y'all have a
Our
fantastic.
You can sign our sign-in sheet.
Absolutely
Great. Thank
Our
you.
December meeting will be 6 and 7.
Right, December 6th and
December 6
7th.
and 7.
The actual board meeting's on the 7th.
Okay, so the review would be on the 6th?
No, 7.
It'll be on the 7th.
Okay.
The 6th is
And that's at the
meeting.
Davy Crockett building, correct?
Yes, that's right.
Exactly.
John, it's good to see you again, too.
Yeah, good to see you.
All right. Thank you very much.
Thank
I
you.
won't take any more of your time. sir.
Okay, and thanks, Robert. That's a good point.
Yes.
Definitely need to be brought up. Okay, we'll move on to the consent agenda. John?
Okay. This is on your iPads. You get your iPads powered up. On page 94 on your iPad, this is under the meeting materials. There's other attachments there too, but under meeting materials on page 94, you have the minutes from the August 2017 board meeting for your review and approval.
If everyone has had a chance to review the minutes of the previous meeting, I'd like to entertain a motion to approve the minutes.
So moved. Second?
We have a motion and a second. Is there any discussion? not, all in favor say aye. Aye. Opposed? Motion carries.
And there is no staff complaint report, because I didn't get the report from our centralized complaints division in time to add it to the materials, but it'll be on the December agenda.
Okay.
That's it for the consent agenda.
And the next on our agenda is professional society reports. Casey, if you want to start. There's really not a podium, so just speak up and...
I can be loud.
Okay.
Casey Anderson with ACEC Tennessee and the Tennessee Society of Professional Engineers. I'll be really quick today. We have, TSPE has continues to partner with ASCE and is in the middle of offering both a PE exam review class for those taking, I think everyone in that class this time is taking that exam this month. And that has gone really well, and I really appreciate Chris and the efforts of Lipscomb to host us over there. They're doing an outstanding job. The FE review class has also started last month, 3 sessions in, and we think that that's going to be a really, really good thing, both for undergraduate students. It's also open to non-traditional public. People are going back to take the FE. It's open to the public, and so. So that has been a boon, and I think will be a really good thing going forward for everyone. We appreciate the board's participation in the Tennessee Engineers Conference last week. We had about 600 attendees at that conference, which was a lot of growth for us. Liz and John came and did an update on what the board does as a whole, an overview of sorts at the lunch meeting on Friday, which included the ASC student chapters. So we had probably 70-ish students in the audience during their presentation, which I think was really helpful. Very different from what we saw them present yesterday. It was, I thought yesterday was good too, but I thought it was quite good what you shared. And then we also hosted a town hall meeting Friday afternoon with Liz, John, and a few of the board members were there as well, which was a nice opportunity to allow engineers to ask questions about some of the latest things going on. So we really appreciate what your participation in that. And as we discussed in the engineering committee yesterday, the TSPE is sort of sharing, but we will have a committee that is actively looking at the decoupling issue and how we want that to look, but it will be representative of there will be representatives of all of the interested associations and types and technicals, groups, etc., of representative of the entire engineering community. We just feel like it's probably going to be easier to house that in one place and have everybody sit around and talk about it in the essence of time together. And so that if you know of anyone who is interested in joining that group, we're more than happy to have them, but we do have a good representative group at this point and are going to start rolling on that in the very near future. Thank you very much.
Hi, and I'm Don Baltimore with Tennessee Interior Design Education Advocacy. We don't really have a lot planned upcoming. In the legislature, we have nothing planned at this time, but we are, of course, as always, willing to work with the associations and the board on any legislative or regulatory matters. We've had meetings across the state, interior design groups, after NeoCon, where the new design items were introduced. The American Society of Interior Designers Tennessee chapter will have its annual meeting October 27th and 28th. On that Friday night, I believe that's the 27th or 26th, we're meeting at the Frist Center. Many professional designers from across the state have never seen the Frist Center. We want to introduce it to them, let them see it. Our featured speaker that day is, I apologize for not going to one, either Steve Tuck or Kim Henry talk about redoing that marvelous post office into what it is in the Frist Center for Visual Arts.
Nathan.
Good morning. I'm Nathan Ridley. I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects, and we'd like to report that we are pleased that your Executive Director, John Cothran, just came and spoke to our annual meeting in Knoxville in September. and that was well received. It's a nice, as Casey mentioned, we didn't give him as much time as we should have, but he was very kind to come to the trip and made a good overview of the board's activities. And my hope is that we'll be able to work him in maybe for PDH, professional development time. We might do a tag team operation just to spice it up a little bit. Next year's conference is going to be here in Nashville in May, and we're excited about that. Kind of along those lines, the national conference for the landscape architect profession will be in Nashville in 2021, and we're really pumped about that. That just came out. It'll be a lot of work, but we're excited about it. Kind of in the legislative arena, our friends will reconvene on January the 9th. A lot of fruit basket turnover coming up in 2018 because it's going to be an election year. That will affect the players on the chessboard in the legislative session in January. But y'all know when they're looking to run for something else, it sometimes colors their judgment. So we look forward to working with them again. Governor Haslam's term limited, as y'all know, so we'll have a gubernatorial election we have to always watch out for that for the board, and we look forward to that process as well. But thank you for the opportunity.
Okay, thanks. Ashley.
I'm Ashley Cates, Executive Vice President of AIA Tennessee. One report, I'll start off with the legislative one, Nathan. This coming year, we're going to be working with the coalition to try to pass historic tax credits. So we're excited about the possibility of getting something approved by the legislature so we can begin having preservation within the municipalities, not just the urban areas, but the rural areas as well. So that'll be a big impact for the small communities. We're also going to be working on, every year there's zoning legislation coming up, so we'll be monitoring that. Zoning legislation. And then we have, as you all know, Fuller, she's on our Emerging Professionals Committee, and so we've just started that committee up a few years ago. And it's a really good group of young architects that they're coming together to try to really promote architecture and do the next generation of architects. And so we did an EP video challenge at our conference this year to get them involved, because one of the things we've noticed with our state conference is that we need to involve our younger members and get them involved in the profession and professional association to advocate for the profession. And so we had an EP Firm Friendly Award as well. That went out to 10 architecture firms across the state that would support their architects getting licensed. So we found out a lot of good information. There's some firms that actually that pay for licensure, that once the architects get licensed, they will pay for all their fees. So it's exciting. They had a competition about that, and so we're hoping to recognize more firms as we move forward on that. And then we also recognize our newly licensed architects. Thank you, Mr. Cochran, for giving us the list. We had I think there was about 30 that was licensed this year, and we had about 14, I think, come to the convention to receive their awards. So we also try to, the Architecture Foundation pays for their registration. So that can be a little expensive for young people. So the registration is covered. So we're excited about that. And that's a really good group. We definitely want to be able to work with the board and more discussion on the pre-licensure titling. We know that that's out there, and we want to have a productive conversation on how we can come to a resolution on that. And then we also, my board, the AIA Tennessee board, has not discussed the recent FAQs QBS discussion. So I can't speak for the board, but I can speak the fact that AIA Tennessee does support QBS and enforcement of QBS. So whatever we can do to help facilitate any type of education, as well as enforcing the statute, that's the major concern that we have, is the enforcement of the statute. Usually what we normally did was, I think this is the way it's been for years, we would reach out to the board and would just write a letter stating the facts, that this is the state law and this is how it works. And usually that's enough information that the county or municipality understands the process and will make an amendment. So we've never really received any pushback on that from the county and municipalities.
And so we want to work with the state and the licensing board on how we can get that QBS statute enforced.
Okay.
Also, just real quick, conference next year is going to be in Franklin, July 23rd to 25th. We welcome any and all design professionals to attend. And then we are going to work, can't promise it's official, but we're trying to work on a design and construction day on the Hill this year. So engineers and architects and the contractors are trying to build some momentum around that and making it a little more exciting for our members and for the legislators. So we'll send out the date. We'll probably have that at the December meeting. So, do you have any questions?
Thank you.
Thank you.
Legal case report. Sarah, can you give
Hey, good morning, members of the board. We should have a physical. Is anyone missing a physical copy of the legal report? We have the legal report for you today. We separated the complaint number. We indicate our initials, SRP for me and SDB for Shalina. We did have a small announcement of changing in legal. Just it's not well, it'll be sad for me, but Shalina will be rotating off the board, and then proceeding forward, Liz will remain your board attorney, and I will remain your sole disciplinary counsel attorney. This is an effort from legal to kind of balance out our workloads, and so we can give you all more of our attention rather than being divided amongst so many different programs. So hopefully it'll be seen as an improvement. Shalina's still our supervisor, so she's still going to, in many ways, probably be available to us. So we appreciate her for that. And any cases that Shalina has or I have, we'll be moving forward on once we own. So if we own those cases, we'll own them to the end. So no worries about things swapping and having to follow back up. So hopefully you won't feel much of a shift there. Going on to the legal report, the first case entry today is mine. This is 2017-030641. This is a case of unlicensed activity. It's a little bit unique, and I'm definitely looking for insight from the board on whether they approve this recommendation, and I'm flexible on it. In this case, we have a respondent that, for the second time since 2015, was identified to board staff as holding themselves out as an architect. The respondent owns or owned a quote-unquote design studio, but they listed themselves as in architecture on Facebook, on their Twitter pages. Respondent's website stated it's a full-service planning and interior design firm, but as services it listed as franchise architecture, residential architecture, things like that. The respondent does hold a BS in architecture, but is not licensed and has not been licensed, I don't believe, with this state. We did do an investigation into this one. The reason the 2015, you'll see that there's no disciplinary history, despite what I just said. That's because in 2015 the process was a little different. The people who processed complaints could never locate this individual, and therefore the complaint never really came forward because there wasn't an ability to find this person, but they have come back now. Or allegedly. Respondent at that time claimed to our investigator that he doesn't live here anymore, that he lives in Montana. However, our investigator noted that the respondent's Facebook continues to list respondent as residing in Tennessee, and all posts shows respondent to be in the area and the business that was allegedly operating. So this individual does reside near one of our state lines, so sometimes posts did appear to be across that state line, but if you lived in that area, it wouldn't be unusual for you to probably be dibbling back and forth between the two different states. The respondent did claim that its operation does not violate the law because they only do tenant infills and personal residences. Pictures of projects on the respondent's former website, since they did pull it down after they received my complaint, showed franchise locations like Subway's, Little Caesars, McAllister's, kind of your typical chain restaurant infills, and some independent standing structures from what I could tell, but mainly things that were going to be put into strips. The website stated it would provide layout and space designs for franchises. The previous version of the website from the complaint in 2015 also listed commercial projects. This no longer was on the website when I saw it before it was removed, but back in 2015 it was there, including a dentist office, a new storage, conference room, and playground for the Ronald McDonald House. I also located a news article that described respondent's renovation of a commercial property. And in that article, the respondent is called an architect, and it quotes the respondent describing plans regarding the redesign and renovation of a historical property. Additionally, respondent was recently named in action from the state of Mississippi, in which Mississippi disciplined a registrant for plan stamping plans for a respondent in that state. And also in 2015, respondent had a complaint filed against them for operating a firm that utilized respondent's last name as well as the word architecture. The complaint did not progress yet due to the inability to locate the respondent. So there are some mitigating factors. The website is completely gone. I cannot find any evidence that it is online in any place, but I have saved multiple screenshots of it. So, but I could never. Our investigator was not able to get actual plans. What I asked for from this respondent was copies of all contracts with Tennessee residents so I could see the scope of the projects that they were doing. They provided me letters with all client information redacted, so I cannot confirm anything that was listed in any of these. And I have some, it's one of those gut feelings, I have some suspicion that these letters were modified. At one place, they do leave in the address the idea that it's an ice cream shop, so it should be a small, small infill probably. But then in the body of the letter itself, it describes an Orange Theory fitness gym. So I'm honestly not 100% sure if those are legitimate letters. And again, I still don't believe that even though these are franchise infills, that they're exempted out of our requirements anyway. So I don't really understand why that is happening. But obviously the aggravating factors is that we do have a past complaint, inability to locate. This person seems to want to be avoiding the board as much as possible. And then obviously close in time, we have the history in Mississippi of this person having registered architects stamp the plans. And that was the original allegation in 2015. A registrant of ours contacted the board to say that they thought this guy was having a different registrant stamp plans for him. So the complicated reason that this is only a $1,000 civil penalty is that I don't have plans, I don't have consumers that I can speak to, I have nothing to confirm the scope of what he's doing, if whether maybe he was just doing interior design work, I have nothing. So but what I do have is the use of name, saying you're an architect in the newspaper article, saying that you do architecture. I think that at least on that, I have some teeth to say I can overcome probable cause that you were holding yourself out as an architect. Unfortunately, at this time, the file doesn't contain facts to say you practiced architecture in a way I think would overcome the burden on legal. I'm not 100% satisfied with that, so we intend to continue to look forward and try to find more information, and we do hope that inevitably there will be a return, perhaps with some better facts, and we will continue to dig into that. But at this time, at least, I think this is what I have evidence of. So I'd like to request a recommendation for $1,000, and if I'm able to locate the registrant from 2015 and try to get more information, I will bring that back or bring it into the formal hearing with a higher penalty. So that's what I'm asking for this today, but I'm definitely open to any ideas you all have or any modification. But this is kind of what I came to. Sorry, that was a long one.
Sarah, since you're continuing to look, is it maybe a little premature for us to, should we wait, or do you think that by waiting, more harm is going to be done?
That's what I feel. I think that this person knows how to go off the radar and is more than happy to move between states. And the fact that I have him now in contact with an investigator, I think now is the time to record discipline so that if he either reappears or if things happen to come up during the process, I'll use it. But most importantly, I want recorded discipline against him for when he inevitably comes back.
And yet the only teeth we really have are website screenshots from last year, a few years ago.
Yeah, and yes.
And newspaper or media information where he is called an architect.
Yes.
I've been called an engineer and an architect many times.
Correct.
Incorrectly in the newspaper. So I'm cautious about that.
To me, the thing that really does it is the fact that I have all of his professional LinkedIn pages saved, and all his social media. He's very active on social media. So I think that's good for a hearing.
Sarah, do y'all typically do, in association with sending him the fine or the civil penalty amount, do you do a cease and desist? Do you do a forceful, don't do this again kind of a letter?
It is in my consent order. One of the specific things I request people agree to is a cease and desist, which gives us some support later down the road to ramp up discipline significantly.
I have a question.
Of course.
Is it correct to say that if we impose $1,000 fine and he says okay and he pays the fine, Is that the end of the case?
That's the end of this one at the time. I mean, and honestly, that's the sad part about this one. I know he's doing more, but what I don't have anything on it. So the hope is either through the process of this, he gets sloppy somehow and I can find something. I just don't think the odds are good. I think he's kind of slippery. But most importantly, is I can look, when he inevitably, I think he's very tied to the area he lives in. I don't know why, but he's there a lot. If he does come back, and keep an eye on that area, that we can move faster and have more authority to go to the AG's office. That's kind of what I'm thinking in the long run here. Often I can't get the AG to act, to do an injunction or to take any sort of action unless I can show them multiple violated orders of the board, not just one even. So a lot of times in my mind I'm thinking way down the road of when can I have a stack of them, someone denying this board their requests.
Yep.
So that's kind of long term of what I've been thinking.
And the other side of that question is, if he does want to pay the fine, then does that give you the authority to go after more
If new facts would
information?
arise, right now I have all the authority right now to seek the information I can try to get. But he claims he's in Montana, so I haven't been able to physically meet with him. All communication's been by email. The only information I have is the information he has voluntarily given me, which I'm suspicious of. So, and then anything I could find, which he purged the internet. Luckily, before I ever sent the investigator, I knew that could happen and saved everything as a PDF offline. But his internet presence is almost non-existent at this point right now.
Okay, and lastly, is it you came up with $1,000 because that fits our guidelines, so to speak?
Yeah, that's it.
I mean, I'd like to make it $5,000 just to wake him up and get him.
Yeah, and that's how I felt. In fact, John and I had talked about that and tried to bounce ideas around. The only other thing I could think of is each instance of architecture, but kind of going to what Blair said, some of those instances were not really in his control. We even had a case last meeting where I ended up closing it because the person was called an architect by the news, and I never told them I was an architect. You can see here that I'm an interior designer. So the one count, the LinkedIn page, I think is the strongest because that's his professional front to the world.
Okay, we've heard the case, and we have a recommendation here. Do we have a motion?
Do I need to state the motion, or kind of just
Sure.
say something?
Okay, no, that's fine. We have a motion. Do we have a second?
Second.
We have a motion and a second. Is there any other discussion?
Do they member review this?
This is not a member review since I had no plans. It's really a legal determination about use of title.
Anyone else? We have a motion and a second on the table. All in favor say aye.
Aye.
Opposed? Motion carries.
Thank you.
The next case is mine. This is 2017048661 involving an architect. The complainant engaged the respondent architect to perform architectural services, and the complainants had plans from a residential designer in CAD format. However, the respondent architect said that the home couldn't be built from these plans because it would not be structurally sound. So the complainants retained the respondent's services. Later, the complainants alleged that the respondent stated that he could not reduce the square footage of the home in order to keep the price at the same. So what happened was there was some disagreement, and finally the complainants were able on their own took his plans and put overlay on the respondent's plans and then made some changes themselves. All along there was some dispute about payments. The project continued on. The complainants paid, hoping that the respondent would address all their concerns and make all the changes. The complainants also wanted a basement, and the respondent would never address this. Also, there was some problems with an LFE, which is the lowest floor elevation, and the respondent had told complainants that he had never heard of such a term, and it was not an engineering or architectural term. It turned out that the cost to build this home went from $800,000 to $1.7 million. And the complainants alleged that there was some collusion going on between the architect and the construction manager. They ended up getting a new construction manager and contractor. And that new contractor also said that the price would be in the $1.7 million range. They never got their basement. The respondent did provide a response and said that this was a 10,000 square foot home. It couldn't be built at the $800,000 cost that the complainants wanted. He tried his best to rework the plan. The original construction manager projected it at $1.3 million. They were still not happy with that. Things continued to change, and the respondent realized the scope of work had changed and wanted to renegotiate the contract with the complainants because of the increased budget. The pricing continued to increase, and it went to $1.7 million. The respondent says that he tried his best to work with these complainants. He explained that he had not encountered the term LFE. He usually worked with the 100-year flood elevation. He had never tried to defraud the complainants, as they alleged. They were always making additions and changes. He also mentioned that they were away a lot, and he had to accommodate their schedule, and he met with them on weekends concerning the plans. Essentially, the respondent says that these complainants wanted to build this home at half actual cost. Respondent has been involved in building in the construction industry since he was 13. He's been practicing for 24 years. 15 of those, he had his own practice. This has been reviewed. There was no finding of any violation. Essentially, this was a contractual dispute between the complainants and the respondent. And my recommendation is to close.
Everybody's heard the case and the recommendation for the legal.
I'd like to make a motion that we accept the recommendation from the attorney.
Okay. We have a motion and a second.
Yeah, it does sound like it's just a dispute between the two people.
Any other discussion?
I have a comment, Mr. Chairman.
Okay.
It's pretty, I would be interested to know who could build a 10,000 square foot house for $800,000. I'd like to get them on board.
That'd be a metal building.
That'd be a metal building. Thank you. Maybe.
Any other?
Was the house in a flood zone?
There were flood, yes.
Yes, I believe it was.
The term LFE doesn't mean anything to me necessarily. I'm used to seeing a minimum floor elevation or who knows how it was put in.
Any other?
Frank, you looked at this.
I did. Yeah, I didn't really see any information that would involve us. There was a complaint and a response, which is he said, she said.
Yeah.
But the facts that were presented, just there wasn't anything there. There being no other discussion, all in favor say aye.
Aye.
Opposed? Motion carries.
I'm sorry. The next two are actually companion cases. They involve a professional engineer. It's 2017-055-821, and number 4 is 2017-055-841. The facts overlap in these two cases. So in this case involving a professional engineer, the complainant had requested a structural inspection of a home be conducted by the respondent engineer. And the respondent made the appointment with the wife the complainant made the appointment with the wife of the respondent, and she had represented that she ran the office and worked for the respondent since the 1970s. The respondent's wife came to the inspection appointment at the complainant's home to conduct the inspection and did a cursory structural inspection and took multiple pictures. Later, the following month, the complainant received a structural inspection letter. It was stamped and signed by the respondent. Thereafter, the complainant requested a wall inspection and revision of the prior letter. The respondent's wife stated that it would be done for an additional fee and it would take a couple of days. The respondent's wife returned to the complainant's home a few days later and stated that her husband had Parkinson's disease and had fallen the day before and had to be hospitalized, and she was going to place him in a nursing home. At this point, the complainant asked the respondent's wife if she was an engineer, and she stated she was not. After the inspection, the complainant did not receive the updated letter concerning the follow-up inspection and repeatedly requested the letter from the respondent, and then finally received the letter, but it had no stamp or signature. The respondent provided a response and said he has been licensed since the 1970s and is also a registered land surveyor in the state of Tennessee. The respondent stated his wife has been certified in various aspects of material testing, and due to health issues, he wasn't able to attend the on-site inspections, but he performed the work, and it was under his direct supervision. There was no attempts to defraud anyone concerning any engineering activities. This complaint was reviewed by a board member, and there was no finding of any violation. I recommend that this matter be closed.
Okay. Robert?
So Ricky, you reviewed it. So question to you is, were there any, how did the guy analyze it? I'm assuming the guy's his wife, but how did they analyze it if they, just from pictures, did they have any calculations or any measurements or anything? I mean, was there, did they measure the cracks? Did they measure, was there any of that documentation there?
I think it was, I'd have to look back through her report again, I think, or his report. I think it was a visual inspection to determine what they determined.
What was the structural issue?
Yeah.
This is an old house, kind of a historic house. There was an addition that was in obvious bad shape. It was falling down, and so the report was, this is not safe, this addition, but the rest of the house is sound to go ahead and refurbish. So that was the question on the report, was is the house structurally sound enough to refurbish? So there was, she looked in the crawl space, she looked at the foundation, the footings, took pictures, went back, went through all of that with her husband, the engineer, to come up with the conclusion that they have in the report.
Well, this report, was it obvious from the photographs that it was structurally unsound? Even to a layman?
They were good photographs. I mean, even the mechanical, it looked like it was, not deficient as a report. Right. I showed it to a structural engineer, and it looked like a report done by a PE to the structural engineer.
Okay. All right.
So the addition, you said it appeared to be unsafe.
Correct. The recommendation was that's
going to be removed.
That would be removed. It was unsafe, but that the original house was structurally sound.
So do we have, does the board have a rule about stamping letters or reports like this? I noticed said it wasn't stamped.
It was stamped.
It was
That was
stamped.
the issue was that the claimant really never saw or talked to
Right, okay.
the engineer in this case. But the engineer stamped the report. And
It says without a stamp or signature.
Okay.
That was the second
That was the
letter.
second
That was the
letter.
second letter.
Oh.
The second letter, and when I read in the second case where she is the respondent, it sounded like it was she was given 1 or 2 days to stamp this amendment to the report, and her husband was being put in the hospital or nursing home at that time.
A question for staff. It looks like reading ahead, the next case is the same case, so he's making a claim against her for practicing without a license. Is that what he's doing?
Yes, that's correct.
Okay. So I just wanted to bring that up so we make sure we're talking about the same. It's the same exact case.
Yes.
It's 2 different issues.
But what I understood from this report here was that she made no claim to be a structural engineer. And she provided no letter that was signed as if she was representing herself.
In her answer, that she said that she was consistent on saying she wasn't an engineer. Okay. She works for their company. She's a part owner of the company. So there's, I looked at our rules about responsible charge, and we just simply, we don't say that a registrant has to do all the work. We say that they have to be in responsible charge. So her description of what he did and she did, I felt like met responsible charge. Now, if that didn't happen, if he didn't see it all at all, then that would be a violation. But from the information received and from what the report looked at, I can't draw a conclusion that she did not go over that with him and review all that.
Okay.
Question.
Yes.
I know we try to be sympathetic with the case here, and I truly believe Ricky probably dig through every rule that we have. The question in the back of my mind is, at what point do we tell the registrant, okay, this could be sounded, y'all help me out on this, I don't want to get myself crucified. At what point do we start to tell the registrants that perhaps it's time for you to go in next? I don't know whether we can do that, because it sounds like he's in not good health. So yes, I do agree that he may not be on site, but that might affect the public as a whole in terms of his judgment. So.
What's the actual complaint?
The actual complaint is that he did not actually do the work and seal it. That the seal is being used by her, the wife, who is not qualified professional engineer.
And yet there's no proof of that.
Right.
No absolute proof, and yet the report you have gone through seems very thorough with good photographs.
Well, we're not a structural engineering firm, but this is similar to a lot of the types of investigations we do. And not every, in my practice, not every project requires that the engineer go and place eyes on what is done. That is the purpose of the lower paid technicians, to be the eyes and ears, as long as the engineer feels he's operating within his realm of expertise. So if he has operational control of what's going on, he's in responsible charge, and he's willing to sign and seal it, then those people are operating at his instruction.
That's what I thought.
That's the way I read it. I don't, in the absence of other facts, I would say this makes perfect sense to me.
I was very aware of the fact of his health condition and didn't understand how he was able to perform this function, but at the same time there was nothing that indicated that the allegation by the plaintiff using a seal or not performing the work was there. There was no evidence for me to.
I mean, he didn't issue a report that said something that was wrong.
Right.
Is that correct? I mean,
Right.
he didn't say this is structurally sound, have at it, and then Ricky looked at it and said this is falling down. That's not what happened.
No, the report was accurate, and it was a very good report, and there were no problems. There was no inconsistencies between their responses either. He states that he does the work, admits to his failing health. There was really nothing there.
Yeah, I didn't feel like necessarily that having Parkinson's and having a mobility problem after falling down, I didn't come to the conclusion that he could not have reviewed this report and instructed her.
Okay. We've heard the recommendation.
Go ahead. Okay, I understand, but I think to close this case, I think the board needs to do a little bit more in my mind. Will I write him a letter and say, hey, this will come to attention that he might want. I don't know how do we point back to our law in terms of our conduct. I'm not saying he's doing anything wrong. I just want to make sure they understand. How do you draw the line? I don't know.
I think it would be difficult for you as a board to say to him that due to your failing health, you need to stop performing any engineering services. What I would suggest is that if we receive more complaints on him, at some point the board might want to consider review of this particular license.
So would that be something reflect in his file, or is it proper to do it? I don't know. That's all I'm going.
I don't think there's not a mechanism to do that. And at this point, he's only produced competent work. So the only time we'd be able to affect his license status is if we start to receive incompetent work.
Thank you.
Yeah. It seems like, I'm sorry, you were first.
That's okay. Go ahead.
No, I was just saying, well, I was saying, I mean, it seems like that would, I mean, mentally, he's there. It almost seems like we could be like, just because he's not physically, he can't perform well anymore, and mentally he's probably fine. So I would be hesitant to say anything right now, like we said, unless somebody says what you're producing is not competent.
Well, he thought it was important enough to stamp the original letter or report, but not the revision or the subsequent one. So I think that's a problem. I don't think it's a good enough excuse that he wasn't able. It's just still if he modified the original report and wasn't stamped, I think that's a problem, and we should have some correspondence about that. Unless our argument is it's not required to be stamped.
I think she may have ended up providing that stamp.
Yes, I believe.
But it just couldn't be done in the 2-day time frame that the complainant requested. But eventually that was submitted stamped. Is that right? Isn't that right?
Yes, sir. That is correct. Eventually, the complainant did receive a stamped letter.
Well, I don't think you send it out to start with when it's not stamped. It's not fair.
I think she had a reason for that.
Would someone like to make a motion?
Mr. Chairman, I'd like to make a motion that we accept legal's recommendation to close the case.
Do we have a motion? Do we have a second? Are you
get a
seconding?
second. We get a second and we can.
We can still discuss.
Let's get a second.
We have a second.
Do we have a second? We have a second. We have a motion and a second on the
No,
table. Now, is there other discussion? Ms. Ware?
May I? Thank you.
You may.
I would just want to say, Philip, that I would be very hesitant to issue any type of a letter or warning or direct staff to suggest to him that the method by which he went about the business was incorrect or unacceptable, simply because I think in a lot, not just mine, but in a lot of our businesses, this is how we do business. And I think it would be wrong of us to imply that he can't do it the way everybody else does it because he's got some kind of a health issue.
I'm good with that. I just want to
Is that okay?
Yeah, I just wanted the legal to give me some clarity on that. Sometimes a fine line you walk between for to protect the public health safety, and a lot of time engineering is always a trade-off. You give up something to have something. But at the end of the day, if we fulfill a mission, something like we are at this present moment, I'm okay with that.
Mr. Campbell.
Was there any scope of the services? Was it hey, come and do a visual inspection, or did they do a structural inspection?
Scope of work.
I didn't see the agreement, you know, the scope of work agreement, but the report was a visual inspection.
Okay, and I'll shut up after this, I promise. But the only thing that concerns me, and I'll go along with the recommendation, we have and we've experienced it because of some of the Gatlinburg stuff, where people are kind of doing these drive-by inspections and really not doing a thorough analysis of what's going on. And that concerns me, and these are registrants that are doing this. And again, I don't have any physical proof, it's just hearsay. And the only thing I saw, or looking at a report, is that you're right, we send technicians, but generally the technicians collect more than just a visual record. They'll do some measurements. You know, is the room square? Is there a crack, and is it 2 inches, 3 inches, no inches? I mean, there would be a little bit of some measurement data there. So I don't, again, I know a lot of these are done on a visual level. I don't think that that's something that is a good standard of care for engineers or architects to do that are doing that. I don't, and I would, well, I'm gonna go along with the recommendation, but I'm almost wondering if we shouldn't say, you know, the report, just a visual inspection needs to be also followed up with some other measurements or other technical data. So, anyway.
Well, just quickly, I thought I might respond to Steve's question, just because I found on the respondent, the second respondent's answer was the timing of when the claimant wanted to get that second letter was in a very short time frame, where the engineer was moving in between hospitals, trying to get blood pressure stabilized. And she says that she's well aware that the letter without a seal and signature is not acceptable. She sent the unsigned letter in an effort to let Mr. Cole see what would be forthcoming, even though it could not meet his deadline, and that she was in error in not stating this unsigned report preliminary. So that it was addressed.
Thank you.
Is there any other discussion? We have a motion and a second. All in favor say aye.
Aye.
Opposed? The motion carries.
The next matter is the companion case alleging the unlicensed activity by the wife of the respondent. She provided a response and stated that she has a bachelor's degree in English. She has run the business since 1976 full-time and is also an owner. She's attended some workshops, taken surveying classes. She's a certified masonry inspector, and also a level 1 certified person for erosion prevention and sediment control. This was reviewed by a board member. My recommendation is to close the case. The respondent in the previous case clearly was doing the work and responsible in charge. So I recommend that this be closed.
Okay, we have a recommendation. Do we have a motion to approve the recommendation on this case?
Motion to accept staff's recommendation for closure.
We have a motion. We have a second. We have a motion and a second. Any discussion? There being no discussion, all in favor say aye.
Aye.
Opposed? Motion carries.
Next case is mine. It's 2017-047311. This one was turned in by a registrant engineer. for a oil and tire change location that utilizes the term engineer in its name. We've actually had this complaint before us, I think two years ago, John? About 2 years ago, and the board decided that it was pretty apparent what the purpose was, that it wasn't misleading to the public, that no one would interpret this business as doing engineering work, that it was more a colloquial use, and this board provided that respondent with a letter allowing them to continue use of that name, and so I requested this board continue to uphold that since there's no chance to mislead the public and close this complaint.
Okay, you've heard the case. We have a recommendation from legal staff to close. Do we have a motion?
So moved.
Do we have a motion? Do we have a second?
Second.
We have a motion and a second. Is there any discussion? There being no discussion, all in favor say aye.
Aye.
Opposed? Motion carries.
The next one is 2017-044101, and this one, the complainant, I'm not 100% sure what their relationship is to the respondent, but clearly someone involved in the project turned in the respondent for allegedly producing incompetent stormwater pollution prevention plans that resulted in possible harm to nearby properties. Both Kathy and Robert reviewed this for me, which I appreciate both of you for doing that. Kathy came to the conclusion that it appeared that it was more of a complaint about future concerns, that nothing had really occurred, and then wisely it directed me towards Robert to do a thorough plan review, and there you could see the points that Robert found, and ultimately I think we were all in agreement that there didn't appear to be any violation here. And of course I would turn it over to Kathy and Robert to talk about anything on that they'd like to for this complaint, but I have recommended that we close it.
Okay, we've been presented the case from the legal staff. We have a recommendation to close. Do we have a motion?
So moved.
We have a motion. Do we have a second?
A second.
We have a motion and a second. We have a discussion. There being no discussion, all in favor say aye.
Aye.
Opposed? Motion carries.
The next matter is mine. This is a representation to the board. It's matter 2017020561. This involves a complainant who's a registered engineer and a respondent who's an architect. The respondent provided architectural services and submitted a civil site drawing in December of 2015 with subsequent revisions. In 2017, there was some plans for substitution of the landscape design, and at this point, the complainant states they were not informed that the landscape design that was submitted had the complainant's P stamped on it. What happened here was the city planner had requested a landscape plan be submitted after the submission of the initial drawings, and they were to some extent informally submitted, and the communications were with the city planner and the respondent. Now, the landscape plan was submitted with an overlay, but there was no seal by the respondent. There was no revisions that were done as a result of that landscape plan, and the complainant was advised about the landscape plan development, including there were multiple emails that were exchanged that the complainant was aware. The board, my recommendation previously was to authorize a civil penalty in the amount of $500 for the respondent's failure to properly seal the design. And the board decided to approve that and also sent a letter of warning to the complainant to make sure that in the future they have plans that are properly sealed when there are multiple parties involved. The board also required that this respondent take and pass the laws and rules examination. there has been a plea made by the respondent in this matter to the board, and they have written extensive letters to me about the details, and they have stated that there was no confusion at any point by the client concerning the preparation of the landscape plan. And this landscape plan didn't technically require a seal by a landscape architect because there was no expectation by the city planner that the landscape plan be sealed. And they referenced me to the board's reference manual on page 11 that stated that landscaping associated with new and existing construction of buildings of 5,000 square feet or more or greater than 2-story require the use of a registry. In this case, the landscape plan was prepared for a single-story residence of 2,800 square feet, and the landscape plan was not necessary. The permit that was obtained based on the PE plans had nothing to do with the landscape plans. And the respondent reiterates that they were under the impression it was an informal submittal. The respondent asks for a plea of leniency and reconsideration by this board. The respondent has 47 years of experience in the industry with an impeccable record of no history of complaints. They have never been sued civilly, and there's never been a building failure on any work performed. The respondent would like the board to consider that recently the respondent's business partner has retired and he has had to close the business and liquidate the business after 30 years of practice. He plans on starting a new small business in the interim for the last few years of his practicing and would like to start a clean slate. The respondent never intended for any confusion or miscommunication by any of his actions, and there was no intent whatsoever to harm anyone. The respondent would also like the board to know that there was some animosity between the firms, but never thought that it would rise to this level, and would respectfully request reconsideration of the disciplinary action taken against this respondent, and pleas to all of you for leniency. My new recommendation is a letter of warning be issued to the respondent.
You've heard the presentation of the case. The recommendation from legal is a letter of warning issued to the respondent. Do we have a motion?
I'll ask some questions.
Okay.
Before we have a motion.
All right.
First of all, board member, I didn't see a board member review on this.
This was reviewed by a board member, and the board member is in agreement with the original recommendation and the action taken by the board.
Okay, board member.
We said $500. It's lower losing.
Board member is agreement with $500. Okay. So, 2 or 3 questions, and I read, I think actually his, to me, his rationale digs a further hole. There was no confusion by the client, but the client's not the person here, okay? He actually left, and I'm trying to get my facts right, he actually left a seal from the engineer on a plan that he overlaid. Is that a correct fact? Okay. The engineer, the engineer is the complainant. The engineer knew explicitly that they were going to leave the seal on, or the engineer said you have to have a landscape plan done?
I don't believe that they said anything concerning a landscape plan. This was a communication by the city planner and the architect that there was a landscape plan necessary.
Okay, but the engineer did not know that that architect was going to use a document that had their seal on it. I mean, the engineer didn't say, please go ahead and use this document with my seal on it, everything's fine. I'm trying not to be too glib about that, but
there was never permission given to use the seal for the landscape plan.
All right. So we have, and again, the process of overlaying a landscape plan on a civil drawing is done constantly for
Yes.
very good reasons. Usually that seal is either scrubbed or what, if it doesn't require seal, is not done at all. So my thing is, the respondent who did the landscape plan was not incorrect in doing the plan. Okay, I mean, there may be some disagreement, but I think in some cases that an architect certainly can do a landscape plan. But the ability that they left the seal of the engineer on is incorrect. That's against our, I mean, it would just be like me signing your name or anybody else's name to a document saying, this is my work. And so I think the original respondent, the architect, still the $500 penalty that we had is still adequate. I'm not sure if and I again read the original one, if the complaint never gave permission to use why did we send them a letter of warning? Because if they never gave permission and it was done against their knowledge, did we get something confused? And I know you were out of town, and so I think Sarah presented it, so maybe there was some confusion. I'm just back and forth on some of the facts, but I don't remember.
It was supposed to be a letter of instruction just to let them know that in the future if they intend to have two registrants working a project, they need to be clear on their plans to include that. Now, that wasn't legal recommendation, that was from the board that originated. And I apologize.
Who did that letter, who was it going to?
It went to the complainant.
The complainant.
Yes, and it was related because we had emails in the file that did indicate that they were aware that this landscape architect plan was coming. And so I think the board decided that if you knew this was coming, you need to have specified in your work and done a multiple seal.
But it's different for me to say you need to do a landscape plan and you need to do a landscape plan and go ahead and leave my seal on there because you just do whatever you want to, right? I mean, for me to communicate that you need to do something versus me giving you my signature to do something are two totally different things. I mean, I send emails all the time saying you need to do this, this, and this, but I don't send an empty letter with my signature saying just fill in whatever you want. Hopefully it works out okay.
Right, and we could rescind the letter, but yet again, I can't remember which board member that came from if they want to speak to their reasoning, but.
Well, I think the understanding was that the original complainant had said it was okay to do that. That was my memory of the thing. And there was an explicit email that said it was okay to do that. But I think the email, from what I read here, basically said you need to have a landscape plan or something along those lines.
That's right, there's never approval.
Okay. So I'm going to make a motion if it's okay. I make a motion that we keep the original $500 penalty and that we rescind whatever this letter that we sent to the innocent party in my case. I mean, I just don't know how they have any culpability.
Board members, if I may suggest, this gentleman is an elderly gentleman, 70 years old, and that might not have any bearing necessarily for you guys to consider, but he's been practicing for a very long time. I would suggest possibly considering an informal review of this matter. I know that you've done that in the past. Before you vote to accept the original recommendation.
What damages was he anticipating having from a $500 fine and a letter warning?
I think
to future work that everybody would, it couldn't be licensed in another state, or what is it?
No, this this particular respondent does not have any prior history of any complaints whatsoever. This is rather alarming. Also, the issue of retaking the exam. That's also a issue for the respondent.
Didn't have to retake the exam.
Law and rules.
And pass it.
I know we have a motion. Did we get a second?
So moved. I mean, yes,
We have a-
second.
We have a motion and a second. Is there any other
What
discussion?
was the motion?
The original $500 penalty, to keep the original $500 penalty and then rescind the letter of warning that we sent to the complainant, because the complainant never gave permission to use their seal in any kind of manner.
I think it was a letter of instruction according to the minutes.
Okay, well, it says warning here somewhere.
New record.
That's the new record.
It may have been. It may have been. Because the original facts as presented said that the engineer had given permission to use it with their seal on it. There was an email explicit to that, is what I remember. And I may be, we'll go back and listen to the thing, but that's what I remember, that they said that there was an email that said it's okay to use my sheet and seal, just put your plan overlaying on top of it. And
Kind of related onto the drawing because the complainant wanted to
Right.
make sure that it matched.
yeah, but there was my understanding was an email that said that's okay to use that with my stamp drawing.
That's what I'm saying, that's what it says right there.
Yeah. So that's different than here use my base map and do your own thing.
I just want to ask some legal one more time. So the main reason why you want the informal review is just the fact they haven't had any other, and they're concerned they can't retake that laws, just if they go through this, they're...
Yes, the respondent has asked for a plea of leniency in this matter, and that's why I'm presenting this to you, so that you might reconsider that and maybe an informal review where this can be looked at very closely by a member of the board.
Is it mostly retaking the test part of it, or just the $500?
I believe it's yes, the penalty as well as the exam.
But neither one necessarily weighted more than the other. I was just trying to figure out, what was the impetus for, is it just don't want to take that test again, is that it? And
I believe it's the overall disciplinary action being taken against
Mr. Campbell?
So, and again, I didn't know that the informal thing was an option, so I'm going to go ahead and, if it's okay with my second, I'm going to rescind my motion and restate it. If it's okay with the second, that's very good. I still, I would like to have this matter brought to an informal review. Is that what?
Conference.
Conference, okay, informal conference. But I still think that a letter of warning, again, based on the facts that I thought I heard last time, which don't seem to be either whatever, that this letter of warning or letter of instruction or letter of anything, it should not go to the complainant, because again, if somebody took their map with their seal and didn't scrub that seal off, that's not their, saying you have to have a landscape plan is different than saying, hey, here's this blank letter, have my signature, have a good time. I mean, that's, okay. That was a crappy motion, but anyway.
And it took a long time.
Yeah, but
Your motion is to take this case to an informal conference.
Yes. Yes.
That's your motion.
I want an informal conference and get rid of whatever the letter that was originally issued to the complaint. Retract the letter.
To the complaint.
I will second that motion.
Okay. We have a motion and a second. Is there any other discussion?
I would like to add, I don't understand. It just seems to me this was a mistake made. It was caught. Someone called their hand on it, and the details we'll find out more about. But it just seems like it was a mistake. And as a landscape architect, we take plans from plans that others produce, and sometimes they come with stamps on them. And the first thing that we do is to remove that stamp. It's just something we as an industry, we just do. So, anyway, that's all.
That's why I said the informal conference might be a better dialogue than just give him a letter.
Yes.
Informal conference.
Okay, we have a motion and a second. Is there any other discussion? There being none, all in favor say aye.
Aye.
Opposed? Motion carries. Thank you.
Thank you, Mayor. That concludes our report, and I apologize for any confusion last time on that. We appreciate your time and patience on the legal report.
And now it's time for the director's report.
I really want to,
Okay.
brought up several times about members reviewing. I think that's a perfect example of one that should have been reviewed by the board member at the time it was presented initially, because it's complicated enough. I think one of us should have looked at it.
Okay, thank you. John? Yeah, I guess. Rick's already
had two.
Yes, a break.
We are now.
Okay, we call the meeting back to order. And I believe we're at the director's report.
Yes, we are. Before we get into the reports on your iPads, just a few items to note regarding National Council meetings. Ricky Bursai, Robert Campbell, Kathy Ware, Elizabeth Goldstein, and I attended the NCAAS annual meeting in Miami, Florida on August 23rd through the 26th of this year. Blair Parker and I attended the CLARB annual meeting in Boise, Idaho. Boise. I love that. On September 14th to the 16th. And you do have reports on both of these meetings on your iPads, meeting materials if you want to review those. But they were discussed in the committee meetings earlier this week. A request has been submitted for Susan Ballard and Rick Thompson to attend the CIDQ, the Council for Interior Design Qualification, annual conference in Alexandria, Virginia on November 10th and 11th. Normally I attend that, but I have a conflict because of an NCARB committee meeting that same week, so Rick Thompson has agreed to attend that.
Graciously agreed.
Graciously agreed.
Use it.
Attend that with Ms. Ballard.
Must be an adult in every situation.
Regarding outreach, I think most of these have already been mentioned, that I spoke at the ASLA Tennessee Annual Conference last month. And Liz and I, and as well as some of the board members, I think it was Philip, Kathy, and Robert, attended the Tennessee Engineers Conference, and we spoke at the town meeting they had there as well as their luncheon. And Frank Waxter actually participated in an NCARB outreach visit to the University of Memphis last week. So thank you, Frank, for doing that. And Robert Campbell and Stephen King spoke at a meeting of the Eastern Chapter of the Tennessee Building Officials Association on September 13th.
Who spoke the loudest? Maybe it all.
Who said?
I think somebody in the audience spoke.
Yeah, I agree.
I appreciate y'all doing that, since I was traveling to Boise that day.
Boise. An all-day travel fest.
Yes, it did take all day, you're right. So I wasn't able to do it, but I thank y'all for doing that. And I've been invited to speak at a Tennessee Fire Safety Inspectors Association conference in Murfreesboro on October 31st. Apparently, they became aware of the presentation y'all delivered at the East Tennessee Building Officials Association, and they want a similar presentation at their meeting in Murfreesboro this month. So, since I actually prepared the presentation,
We modified it, Greg.
did you? Okay, we'll send you the modification. I'm sure y'all elaborated.
Yeah.
In response to questions.
Expanded.
Yeah.
Yeah, I expect so.
Improved it.
You improved it, yes. Administrative issues. As I think everybody's aware, board staff began working from home 3 days a week in late August. That's called the Alternative Workplace Solutions Initiative. And so far, we haven't had any problems with that. Staff's very pleased with that. They're also pleased that 4 positions in our office have been reclassified to higher positions. They were Regulatory Board Administrative Assistant 1 positions, and those have been reclassified as Regulatory Board Administrative Assistant 2 positions, which means they get a slight increase in pay. But it's slight, but it is an increase. So happy to do what we can.
One of the others free cookie.
Now for your iPads, page 107, you have complaint data. And this is just a simple, humble spreadsheet showing our open complaints as of September 28th. At that moment in time, we had 20 open complaints, and you'll see our metrics look very good. That's one of our buzzwords these days. Our metrics look very good. We only have one that's authorized for a formal hearing before the board, which I anticipate might be scheduled next year at some point. Definitely, I don't think we'll be December, so I would plan on that one probably for next year. And our percent on time within the last 18 months is 97.30%. So we're doing really well as far as keeping the complaints moving and not letting them sit, for long periods of time. So got some great metrics there. Then on page 108, you have just the licensing numbers as of, this is September 28th, and you can just see how those numbers over the last, a little less than a year, how those numbers are tracking, and they're remaining pretty steady and consistent. I don't think there's any surprises there. Any questions on complaints or licensing data? And financial data, you'll have to back up on your iPads, as that was discussed earlier about the Finance Committee. That's on page 84. And on page 84, you have a summary report, and really no surprises here at all. Our revenue is remaining consistent with the previous fiscal year. This is for the fourth quarter of the last fiscal year that ended June 30th. No surprises there, and expenses have remained consistent as well. Based on our estimated revenue and expenses, including estimates of the expenditures, most of those are not estimates. The estimates are the cost backs that we pay to our department, legal investigations, the commissioner's office, etc. With those estimates, we think we'll have a year-to-date reserve balance close to $300,000 surplus, which will give us an estimated accumulated reserve of a little over $1.9 million. So that's what we're tracking towards. I'll have the final report on fiscal year 2017 available at the December meeting. I may get it this week potentially, but today potentially, or next week, but we'll review that at the December meeting. So that's when we'll have the final cost backs and so forth for you to review at that time. But behind the summary sheet, you have the details if you want to look at the pretty pie charts and so forth. You can peruse that information.
Question.
Yes.
John, I think there was a comment made about since staff is working 3 days a week, does that mean your rental space or your cost back will be less?
Right, that came up in the Finance Committee meeting, I believe. I think there is that possibility that we may see somewhat of a reduction in our rent over time. At this point, we still occupy the same space, but the anticipation is, we don't have a date for this when this is going to happen, but eventually we're going to share space with other programs. It's called the open office concept. I think we're going to share space with other programs. So I would expect when that is implemented that we might see a reduction in the rent costs. I don't know if it'll be significant or not, but probably not.
This question may be asked better at the Finance Committee report, so I won't ask it twice. But when I start looking at our numbers, is there any way for the Finance Committee, possibly in the next meeting or two, to sit down with somebody who is maybe more in line with governmental accounting to look at kind of our run rates that we're going through with money and start looking at this? I think one of our hesitancies on fee reductions and some of the other things has just been, not knowing exactly some of the ins and outs of how those accounting procedures are, what are acceptable balances to have. And I think somebody from that has that, accounting background.
We have a CPA in our division.
Okay, well, that may be helpful.
He's been to our meetings before.
Yeah,
okay.
When we've discussed, right, Bill
We
Huddleston.
can ask him to prepare something.
Or just come and talk to us about some, is 100,000 too much? I don't have any clue or any good feel for historical as well as going forward. And I just don't want to, and again, probably I'm asking this wrong time. I think we've got some room to do some things, but I don't want to do the wrong things and have something that's a one-time event that we get ourselves in trouble on. So anyway.
Yeah, we'll be happy to do that. We could ask Bill maybe to come to our next meeting at some point in the near future.
Or our finance committee meeting instead of taking the whole board.
Finance meeting, right.
Can I add on to that? That one of the things that this board is always passionate about tracking our reserve. As you can tell, it's right now at 1.9. Way back. The reason why we started with this grant money is because we want to spend down the reserve. But I think the conversation would be what is considered too much.
Yes, I agree.
And it's kind of like we always criticize other huge department that has $21, $22 million in reserve. Is that too much? I think that needs to be brought up and discussed. Thank you.
Kathy?
Yeah, the only thing I would add to that is I would be very curious as to some metrics associated with number of registrants. So revenue per registrant and expenses per registrant as a historical perspective on how things have changed over time. So maybe that's something we could ask him ahead of time and he could give us some perspective on that.
And you said
the CPA.
Revenue per registrant, what was the other one?
Expenses.
You mean like how much we collect from
No, total revenue divided by total number of registrants over time. Is it a number that continues to go up? We collect more and more and more per registrant. Is it even? Is it flat? Is it declining?
Okay, I got you.
Trend data for key metrics that might help us see something coming down the road that we otherwise wouldn't be able to tell just by looking at raw data.
All right, okay. And just bear in mind that these are still estimates and cost backs, so I mean,
Oh, sure.
I wouldn't anticipate, because I got these estimates from Bill Huddleston, our CPA, I wouldn't anticipate that there's going to be major differences between this report and the final, but yeah, there could be some changes, certainly. So. But I should have the final one to share with you in December.
Just an opinion of the board. If you can get Bill Huddleston to speak on these issues, would you rather it be just to the finance committee or to the whole board? Because I'm seeing a lot of questions coming from non-finance committee members.
And that's a small committee, right? I think we only
About
have four people. Yeah.
I'm sure we could schedule it
I
at
would-
a time when the other committees were going to meet, and then if people are interested and they want to sit in on the finance committee, unless you prefer it to be at the board meeting, I think either option.
Any idea how long that would take? 30 minutes?
The last time Bill spoke at one of our meetings, I think it was for our motor vehicle commission, maybe 10 or 15 minutes.
Okay. I think it'd be good for the whole board. I think it'd be good for the whole board. So if we could,
I was kind of thinking the same thing Liz was, that if it's a finance committee, but it's at a time when the rest of the board could attend, that might give that a little more focus than having it at a board meeting where we've got business to do and people are.
as long as it's not at 8 o'clock.
How about it?
That's what I was going to suggest. We could do it before.
Okay, not 8 o'clock.
And
start the board meeting a little later.
No.
Yeah.
But I agree with what we're saying. I think it's going to be more than 10 or 15 minutes because I think we're going to be asking some, hey, if we do this, what if we do that? How long does it take, this to go? We've got this fee, we've got this. What does that mean? And try to, again, looking at it from some historical perspective stuff. And I think the whole board is definitely interested in it. The only reason I said finance committee is just because but I think it needs to be offline from a board meeting because it doesn't just need to be a presentation. How we need to actually kind of dig into what if we do this and don't do this, and when are we going over a cliff, or are we that we need to.
Well, no, I apologize. I meant that Bill's portion would be the 10 or 15 minutes and not necessarily your questions and answers. I meant his presentation portion. So
I think
that
we're
would
going to be
longer.
asking more interactive stuff than just a presentation type thing. So.
But regarding that, would it be possible to have the committee meeting, say, beginning at 9 o'clock and the board meeting shifting to a 10 o'clock time?
I don't see why not.
Easily do that.
I was kidding about the 8 o'clock.
I was trying to watch out for our chairman here.
I think we should do it at
8:30?
I don't see why not.
Yeah.
Yeah. Okay. So
As long as we notice it at the time, I think that's fine.
Maybe we could do that. 8:30 could be the finance, and then we could do 9:30 for the board meeting. That way, we're not shifting the times.
Okay.
that
Yeah, that's
much.
good.
Here we go.
Okay.
Here we go.
Would that be in December?
Depending on whether he's ready.
We could probably do it in December. That should
Yeah, I
provide
don't
adequate.
see
We usually have
Party down.
Christmas
Tied up
lunch.
that day.
Yeah, it might interfere with Christmas lunch.
Well, we're gonna talk about that offline.
Anyway. Well, that's our tentative plan, okay. And that's all I have for the director's report.
Okay.
Any other questions or comments? Suggestions?
We'll move on to unfinished business. And John, if you want to go with the action items.
Yes, that's on page 109 of your iPads. It's a shorter list this time. It's mostly legal. The reference manual, that would be an ongoing project, and we discussed that in the publications committee, that we're not in the process of updating that in the near future. But we recognize that there are the need for revisions. And then there's several items under legal counsel. The proposed rule changes, they approved in April. Those are in process. We got them back from the AG. Did you?
Are you asking me for a rules update?
Yeah,
Oh,
exactly.
yeah.
That's what I'm doing.
Okay,
No.
yes. So our rules that we approved in April have been approved through our department internally and have been sent out to the AG for review. We did receive some comments from the AG revolving around whether or not we can actually make the letters of recommendation privileged from the open records statute. That's still under review between the AG and our chief counsels. All the other rules from April seem to be moving along without any trouble, though. I should have more of a conclusive answer in the next few weeks as to whether or not the letters of recommendation portion will move through to the governor's office. And I should have a more definite conclusion certainly by December, but that is the only one that's gotten held up a little bit. Our chief counsel had an argument for us, obviously, but that's still under review. And we will have a rulemaking hearing if the board votes today to have one in December on the rule changes that the committees have been discussing, and that will be brought up again today during the committee reports. Is there any other thoughts?
And we did conduct the research into the rule for the engineer committee in regard to experience obtained prior to graduation. That's been discussed. And also the pre-licensure titles. We provided information on that as well for the architect. And again, the 2018 legislative proposal regarding the architect experience requirements, whereby they would simply be required to complete the architectural experience program without the experience duration requirement. That has been submitted. We haven't heard anything yet as to whether that would make it to the governor's package, but
I didn't hear any negative feedback from that, but I also have not heard if it's moving forward.
we may see that next year. We're not sure at this point. That's it for action items.
Okay. Next item, committee assignments. And I guess I'm in charge of that, but one assignment that's already been made is Ricky Bursai is now the chair of the engineering committee. And Philip Lim is going off the board. And so on the nominations committee, I'm suggesting Rick Thompson become the chair, and Phil will just go off of that, and the rest of the committee members stay the same. On the grants to higher education committee, to replace Phil, I'm recommending Brian Tibbs take that position. And Law and Rules Committee, Laura Reinbold is going off. I would like Kathy Ware to be on that committee.
Do I have to wash the dishes when we finish?
Yes.
That's all voluntary.
Yeah, I mean, everybody needs a dishwasher.
Technically, you'll be the low person on the totem pole.
I'm recommending taking myself off the Outreach Committee and adding Stephen King to the Continuing Education Committee.
You said outreach.
And
Are you taking
You
off
said
the
outreach.
continuing education?
I'm sorry, what was that again?
You said you took yourself off outreach, but you were putting him on continuing
I
education.
took myself off of Outreach, and I'm adding Stephen King to Continuing Education.
Oh, okay, so nobody's replacing you in outreach.
That's correct. And I'm reserving spaces there, and it may change a little bit in December, but when the Alton comes on, I'll of course want to reshuffle this son and get him involved in these committees. And other than that, unless anybody's got any complaints, that's what I'm proposing. Okay, is that good for you?
Yeah.
Okay.
Sounds good.
Thought you had a question. Moving on to new business. We have a good topic here to discuss. The QBS update, QBS FAQs updates, and I think now it's just FAQs updates in general.
Before you get into that, Matt.
Okay.
I wanted to bring up two things, and it's under, before we get into all these
Okay.
other issues. One is, in the future, when we have visitors who come into the meeting, and it's after the meeting has started and visitors have introduced themselves, can we have a policy whereby the new visitors have to introduce themselves? Because I saw people in the room, and now they're gone. And I don't even know who they were. But I don't know why they were here, and I don't know what their purpose was, and if this is a public, if this is being recorded, and this is supposed to be a public meeting, and we have visitors, then I would like just to make a point that those people should be acknowledged.
I think most of the people introduced themselves and
Should
also
sign
signed
in.
in the sign-in sheet, but
Did they
there
sign
might
in?
have been a couple that came in between the rounds of introductions. that we
There were
missed.
two sitting over here and one or two sitting over there.
I don't know what they were here
I
for,
don't know either.
so.
Well, that was Middle
Our-
Tennessee AIA.
Yeah. I knew you didn't.
I didn't know. I mean,
Didn't help you.
I'm sure it wasn't really relevant, but just for future reference.
Yeah,
If
and
they
if,
come in.
I
And there was a little
think
more
if any
shuffling
of the
than
board
usual
members
here for
want
some
to,
reason.
if you see someone come in and you want to acknowledge
Just
them
ask
as a
them.
guest, just, yeah.
Yeah. Good.
And
Didn't
then
have a
second-
password.
Secret handshake. Secret
handshake.
handshake.
Yeah.
And then the second thing, I mentioned this to John earlier, and I didn't know if you all thought it was worthy of conversation. If it's not, we can move on. But I feel somewhat bombarded by all the different requests for review of applications and whatnot, and I was wondering if anybody else feels that way, or if there is a way that we could get on some type of a schedule, if that's anything anybody has an interest in, that you would know when the applications are coming, so that, I mean, for my purposes, I need to schedule that time to actually review all those applications. And staff does a wonderful job of responding to the applicants, and that's what we're here for, and I get that. But they'll get me packages of 15 to 20 like they do y'all, and they just come in waves sometimes, and then other times there's a huge gap, like I hadn't seen one in a while. But if there was any way that we could schedule that so that we knew when it was coming, because I feel inadequate in my ability to respond sometimes. And I know that they're sitting around waiting, and more importantly, the applicants are sitting around waiting. And they want to know, am I going to get sit for the exam in October or not? And so I work off the deadline, just like they do. And if anybody else feels likewise, and if you don't, then I'll just live with it. But if there is any purpose in trying to establish a schedule for the review of applications, that's something I would love for us to take up. Thank you.
Send them every day at 8 a.m.
Every day today, you have to be done by 12. Yeah.
Have to have it by 9.
And just for information, of course, the number of applications received fluctuates quite a bit. Certainly before exam deadlines, we get a lot more. Most of the comedy applications, I think, right, Wanda? I review, because they're model laws. Those are ones where I just make a recommendation, you sign the memo and so forth, so you don't see those, of course. If they don't have an NCAAS record, the comedy ones do go to the board members for review. But yeah, that kind of complicates the scheduling, I think, just the fact that we go through periods where we receive a lot more applications. So if you have a set schedule, that could result in some inefficiencies in the processing of applications potentially, but we're certainly open to any suggestions that the board has. And I think it has been mentioned maybe that using associate members to help more with the review, at least of the exam applications, potentially employing them to do an initial review where they could identify any potential issues or problems, so you could focus more maybe on those applications. So just an idea.
Well, I think before we go down that path, I don't know what, I mean, we talked about this a little bit, that is there something that prohibits that from happening? And I know the voting member has to put their signature on it. My opinion is, if they're going to do a cursory review, that doesn't really help me that much. I just, once I get started, I go. And
well, I think the question is, ask our attorney to look at the code. As I read it, pretty much anything the board asks the associate members to do, they can do. Now, the policy is different. I read both of them, policies, but I think the Tennessee code says it's pretty general. So it may be that whatever the board wants to do, we can do.
Obviously, associates are not voting members. You can't vote on an application, but you can make recommendations.
I will review that question with my chief counsel, and if we are able to have associate members do the review process, we could reach out to you obviously sooner than the next meeting and let you know that process can start. But that's something that I'll need to check with my chief counsel on.
John, just a little bit of history lesson here. The reason why associate members are brought in here is because they help. And the reason, not only that, the reason why they want not the associate members to have 3 or more votes is because you don't want an imbalanced situation in a voting situation. So architects have 3 votes, we have 3 votes. But I don't think so there is anything to prohibit us from actually giving any help, because I was an associate member for a long time, and it's just about everything. And the only thing I just tell Robert Senior what to do, I mean, Mr. Campbell Senior.
And the policy for associate engineer members mentions review of applications with final recommendation for registration by engineer board members. So that's part of it.
But the law doesn't even go that far.
Well, no, yeah, the law doesn't.
Whatever the board directs.
Yeah, the law doesn't specify that. It's just a policy of the board that associates can assist with reviewing applications.
Yeah, I think there was a big contention about you don't want to have engineers have 6 votes and then architects have 3 votes. Then if it comes to imbalanced situation, that's why we're not allowed to vote as associate members. But there's nothing stopping us from doing it.
The board doesn't vote on the application to start with. So.
Well, they do individually. In the committee meetings.
The associate members.
We vote in the committee meetings.
In the committee meetings.
We do. This is the voting members that.
So we the associate
the
members.
application.
Yeah, the associate members actually vote on the applicants.
Right.
In the committee meetings.
Right. But they're signed by the voting members.
That's fine.
Right.
Yeah, I mean, I think we all trust
Yeah,
one another once we get to
yeah.
these things.
Yeah, I'm going to ask my chief counsel about that. We can always amend the board policy. It's really, we just need to make sure it fits within the law and rules. But if the policy needs to be updated, that's not.
And actually, we've actually had several questions circulating for some time regarding the role of associate members. Like, can they serve as officers of the board? Issues like that we have never really been addressed.
So you need to go back to the days when why associate members was appointed here, because the board was overwhelmed with other work. Because back those days we receive a black box from the post office every so often.
Like Robert, if if we review and then we've still got to make that doesn't help them that much. The only thing that would help is if we have the ability to review and approve, then they don't have to. That's what helps. Spread that what would I be, 800 applications a year roughly? Spread that out amongst six people instead of 3.
Well, I mean, you're talking about cutting the workload in half.
Right.
I mean,
Yeah.
that's.
Sounds like a good idea.
So that would be the goal if possible.
Give it to the new guy, the new boy. We'll just dump it.
Yeah, we'll just give it all.
I love Steve's idea. I love it.
But I really would also just push for some kind of a schedule, even if it's not something that is strictly adhered to. If there is any way that deadlines could be projected and you can expect to get these number of packages next week or next month or sometime in the next, I mean, anything at all that allows for more planning on the review side. Because when you get a package and you do 15 on Friday night, get them out the door, and you're all happy, and then you go to work on Monday and you get 2 more packages with 30, then you're not happy. It just comes when it comes.
Yeah, and I think certainly, just for you individually, we could certainly do a schedule on when to
Well, I
send
don't want to be treated
applications.
special. Sure. Well, actually, I really do.
Even if the others don't express that.
I just want y'all to know that I want to be treated.
We can do that for you.
Even a special child.
We can send it to you twice a month.
Well, anyway,
Work
I
with
appreciate
you.
it. That's my 2 cents worth. I'm sure.
Okay, thank you, Kathy. Now, moving on to new business. QBS update, or FAQs update.
Well, Liz has said I have to start this off. Just for.
Well, you are the director.
Just, okay. Just for your birthday. Just for it's her birthday. Is today actually your birthday?
Yes.
Okay.
Oh.
All right. Well, I'll start off then. Just for everyone's information, I think everyone's aware of this, but in mid-September, I was notified that in light of questions raised by the QBS FAQs, and I think this is in regard to questions regarding the appropriateness, the legality of certain procurement processes by state agencies in procuring professional services, I was notified that we are going to remove the FAQs regarding QBS for further legal review. And so that's really all the information that I have, is that those have been removed from our board website pending further review. I have not received any updates at this point as to where that review stands, and I have not been part of most of the discussions regarding the administration's concerns regarding the QBS FAQs. So I'm not really in a position where I can answer questions about the department's position.
Who's doing the review?
Legal is all I know.
No, this review was requested by the commissioner. So I also have not been privy to a lot of these conversations and have only heard down through the chain that they were removed. I can only really speak generally on the issue because I'm not part of the decision making for this item. But I do know that there was concern coming from the commissioner's office that the FAQs were being utilized in a manner that was the board attempting to regulate QBS, and QBS is not given to the board for regulation under the Tennessee statute. So in essence, I think some letters were being sent from societies or members of the public that said, well, the board says you can't do X according to QBS, and the board will discipline you if you do X. And the commissioner's office was concerned that the FAQs were being utilized in that manner and has requested a re-review of their applicability and their functions. That's really all that I know right now.
What arm of state government is appointed to regulate QBS?
So the confusion lies that there's not really a department, there's not really a department that has been given the QBS statute. It's really there for the courts to decide if a violation has occurred. It's not regulated by a certain department right now. It's certainly not been given to the Board of Architects and Engineers. So the message I have been given from the Commissioner's office is that our board is not to act as regulators for that statute.
And I know we've probably beaten this to death, but I'll just kind of reiterate the point. We've got a rule. We have to have some mechanism to adjudicate that rule, unless we don't have that ability anymore on any rule. And I think it is wise to give the registrant some indication as to how the board would view certain scenarios when it comes to pricing. And I don't think to wait on a court case, we may have a complaint filed next month that would ask us to decide if a registrant put in a cost proposal on a project, and the board would decide, right? I mean, because it's under our purview to decide based on the rule what that is. So I think the interpretation that we have to wait on a court case troubles me a little bit, because we have the ability to make those decisions like we did today during the legal report. And it's based on our rules. So, and I'm sorry for getting kind of long-winded, but no, I'm not really. It makes me feel better. But I think maybe the term FAQ, I think these need to be, if you do these things in general, the board's going to look down on them, and we may not discipline you for doing something, but these are some good practices. And I brought up the seals rule because under the seals rule we say, put your signature here, do this, don't stamp somebody else's drawing, and we give the registrant some guidance on what that rule means to us.
Well, let me explain where I think some of the confusion is coming from higher up. I definitely see all of the concerns as to giving the registrants guidance, especially as it pertains to our rule that they may or may not violate. I think that the confusion from the people that are higher pay grade than I is when the letters are being sent out to other state agencies and other municipalities saying, hey, your RFQ or your RFP has violated QBS, and the Board of Architects and Engineers says so. That's where I think the Commissioner's office is saying, whoa, 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 these FAQs were not designed to be a regulatory function and don't have authority from our board to stop another state agency from putting something out in one of their contracts. So I think maybe some conversations need to be had to clear that up. Of course, I think it would be beneficial for something to be created for the registrants to have some guidance, but I think right now the confusion lies is, are these FAQs being utilized as a tool to stop other state agencies from putting something in their contract or to make them take something out of their contract? And that's I think why they have been pulled for now until we can clear up that conversation.
And one last thing is that I understand that part of it, but I think that is a simple matter of how a letter may be written, where you say that this, in general, the way that this RFQ is written may put our registrants in jeopardy. They have certain things that are looked on as possibly violating this rule. I just want to be warned that registrants you may have no applicants, no RFQs, because these are some things the board has seen without weighing in on this as an absolute edict from the board of. And I think if that language were modified somewhat, but we just want to give the registrants guidance. I mean, we're going to basically be setting case law by and case law is not the right word, but we're going to be setting precedents by the actions that we take as a board when it's very clear that there are certain things that are wrong. So,
No, I completely understand, and I want to bring all of these points in this conversation to my supervisors and to the commissioner. I have notified him about the comments that were made at the conference last week, which were all very valid points. So hopefully some resolution can take place soon. Unfortunately, I'm not privy to the decision making on that part, but I will try to keep the board as informed as I can, and as your board attorney, be an advocate for what the board is looking to do here.
Are only the FAQs, the FAQs that are regarding the QBS, are they the only ones that are pulled, or have been more FAQs pulled?
I believe that's all I've
Those are the only ones.
So the rest remain?
Yeah, we have.
And they're not in question?
Yeah, we have like some general customer service FAQs on the website, answering frequently asked questions.
Right.
I mean, those are still there. The reference manual is still on the website, and it does contain some FAQs as well. But those are not, of course, related to QBS.
Right.
QBS FAQs, those are pulled.
And I think that comes from the commissioner's concern in protecting the department as well as the board from any unauthorized regulation on the other state agencies.
And I don't suppose they set themselves any kind of timeline to come back with
I
some
believe
kind of
this all
response.
happened within the last week or so.
Yeah.
I've been with you guys the last week or so, so
Right.
I've not had time to meet with them, but I've also not been given a timeline.
Okay.
So Liz, you mentioned that conversation might clear up some of the confusion and direction and how we can proceed. Conversation between what parties? Are there conversations going on above you that none of us are going to participate in, or when are these conversations proceed?
I don't believe that I will be part of the decision making. I believe that they'll consult me for what the board's opinion is, and sort of ask me for a report on the comments and kind of the general feeling. But I don't think that in my position I will get decision making on that issue. However, I do think as board members you should be able to have conversations individually with the chief counsel in our department and also the commissioners if you feel strongly about an issue, and that's any issue with the board. So I would encourage you to reach out.
Do they want to talk to us, or do they want to tell us what their opinions are?
I'm not sure. I've not met with them since this first came out. So I've been here with you guys, so I've not had a chance to gauge the feeling on how that end is right now. I can certainly let them know that you'd like to be part of the conversation. And I think you should be.
Any other discussion on that? All right, John, next item is authorization of travel and speakers.
Yes, each year we do provide a proposed travel budget to review, and this designates who's going to, at least the number of people that will be attending meetings the next year. That's on page 111 on your iPads, proposed travel for next year. Of course, the board meetings, that's included here too, along with the estimated cost for those. But the real focus of this is more on the out-of-state travel, the National Council meetings that we attend for NCARB, NCWS, CLARB, and CIDQ. And we've been asked by our assistant commissioner to limit the number of attendees at those meetings to 5 maximum, which normally, historically, we typically stay within that range, about 5 attendees for those meetings. So you'll notice on here we do have a Southern Conference of NCARB Educators Conference. That is date has not been set for that, but it's anticipated that we'll probably send one board member to that whenever that date is established. And maybe up to 2 staff, because they've had discussions about whether they should provide some training as part of that meeting, maybe CLEAR training, which is what does CLEAR stand for? Council for Licensing, Enforcement, and Regulation, or something like that. They provide training on regulation, enforcement, things like that. So potentially we could send more to that particular meeting. The NCARB Regional Summit has got that at 5 members. Most of those would be funded by NCARB, and they do provide public member funding for one public member to attend those meetings. So for the Regional Summit, I included the possibility that a public member might attend, but that's dependent, of course, on one being appointed by that time. The NCWS regional meeting, that'll be in Charlottesville. The Regional Summit for NCARB's in Wichita. No meetings in Boise next year. Sad to know. But Charlottesville, Virginia is the location for the NCWS regional. And again, we're planning to send 5 to that. 3 would be paid by NCWS. 4 if we send a new member. I don't know if Mr. Heathcote would be considered new or not. I'll have to check with NCWS on that, but it's possible we may be able to have 4 funded attendees for that. NCARB, again, sending 5, and the NCARB annual would send the legal counsel to that as well, I think. Sarah Page attended that this year and felt it was useful, so probably we'll send an attorney to that meeting next year as well. The NCWS annual, NCARB's in Detroit, and the NCWS annual is in Scottsdale, Arizona. Again, sending 5, with one of those being legal counsel, at least 3 paid by NCWS. The CLARB annual is in Toronto, Canada, Ontario. I'm not positive if we'll be allowed to travel since it is out of the country. We'll check on that, but hopefully we can send one person to that meeting.
But I noticed that your name is not on here, and I wonder why we wouldn't add you to this. That decision's not yet been made, so why not add you to this list?
Right.
It's in Toronto.
When?
September.
Okay, that's a good fly fishing.
Yeah, we could add me to that as well. And then the NCARB, I think they are going to schedule an NCARB member board chairs and executives conference in October of next year. They usually have those every 2 years. So I would anticipate that will be on the schedule. But those are all expenses paid by NCARB, so that has no impact on the budget. The CIDQ annual is actually going to be in Nashville next year, so that won't be out of state. So hopefully we can maybe send 2 board members and myself to that one. So yeah, we'll go all out for that meeting. And then there are just $1,000 for miscellaneous speaking engagements to cover mileage primarily. So that is it on that. So, this gives you an idea of the expenditures, but of course, a lot of variables can change that. I wouldn't focus so much on the estimated costs. It's really more just a matter of providing you information on the upcoming meetings, and we do ask for a vote on this so that we can say that the board has approved a certain number to attend the out-of-state meetings and other conferences that we attend. So it's helpful to have the board actually vote on that.
All right.
Need a motion.
We need a motion, please.
Motion to set the proposed travel for 2018 is presented by the executive director.
Okay. Would you like to add one to the CLARB if possible?
With the addition of the
With the
CLARB.
addition of the executive director going to, what's the meeting?
Toronto.
CLARB.
Yes.
CLARB. I'll second that motion.
We have a motion and a second. All in favor? Say aye. Opposed? Motion carries.
Thank you.
Next item is application and examination deadline dates. Page 112.
Yes, that's on page 112. It's our last page in our meeting materials, and I think the law says you have to establish these deadlines, so here they are. We only have application deadlines for the engineering exams now because the others are, computer-based, offered throughout the year. Of course, these eventually will go away too, because eventually the NCAAS exams will all be computer-based. I think in 5 or 6 years is the plan. Those will be computer-based as well. But for now, these are the dates for the April and October PE exams and structural exams with the deadlines, and these are unchanged from what we've done in the recent past. So, for your approval and vote.
This appears to require action. Do I have a motion to approve this
So moved.
schedule?
Second.
Do I have a motion and a second? Any discussion? If not, all in favor say aye.
Aye.
Opposed? Motion carries. And we made it to committee reports. We'll start with the Landscape Architect Committee.
Thank you. The Landscape Architect Committee met. We discussed the recent CLARB meeting that was held in Boise, Idaho. A lot of great information came from that, and it was helpful that John was there as well. He's certainly well respected around the nation by those, but it was a great meeting. Learned a lot. With regard to health, safety, and welfare, one item of discussion, I have mentioned before of potentially increasing health, safety, and welfare hours with our continuing education or PDHs to increase it from the current majority number to 9 per year. And I have not made an official request of ASLA or asked them yet officially, but discussing with landscape architects around the state, nobody seems to have a problem with that. So I will make an official request of ASLA to ask their opinion of this and bring this back to the committee next time.
Okay.
And one additional item is I've requested of council to explore the possibility of an individual who currently with our law, we don't have, landscape architects don't have any way to license somebody that has not graduated from an accredited university. And we have no provision for that whatsoever. And we'd just like to explore the possibility if there's some way to evaluate that. A case has come to me, been presented to me, that it's certainly compelling for us to think about this and maybe make that provision. So I'll just ask for us to explore that.
All right.
And that's it.
Thank you. The Architect Committee.
Yes, we met yesterday, and we have, I'm sorry, I've got all kinds of notes here. We had, I think, 3 items that we talked about. One was we reviewed internally our applications, and we approved that. We had potential law and rule and policy changes, which I would like to defer that to the legal committee discussion as it relates to that. And the one thing that I would like to address for the board is the intern titling. And we've had, we're formerly known as interns, and now we're not because of the 15 that we rescinded. Architectural intern.
Oh, the policy.
Policy. Okay.
Intern.
And so NCARB and AIA and the architects have been in kind of flux about what we need to be called. So, and we the architectural committee agrees with some of the verbiage that has been floated out there in NCARB and with AIA. So, just for the record, I want to read this into the record. The Architecture Committee is in agreement with the AIA's position that supports the title of Architectural Associate. And that is for those who have earned a degree from a program accredited by NAB or who have met education/experience requirements in their jurisdiction and are participating in the National Council of Architectural Registration Board's experience requirements. So that puts us into compliance with several states and NCARB. Am I correct in that? Or do we need to defer this to legal?
Well, I think the titles recommended in the NCARB model regulations, I think, are still intern architect, and I'd have to look.
You're right, and we're not agreeing with that.
We're not agreeing with
Right,
that.
right. That's what's, yeah, intern architect, architectural intern are the two in the NCARB model. Right. There was a motion to change that, I think, a couple years ago, and that did not go through.
But we are in agreement with architectural associate.
That's right.
Is that correct?
So I think the next step with that would be to bring to legal for us to just double check and evaluate whether or not that complies with the statute. And then once we've got the okay from there, then the board could put out publication that that's going to be acceptable moving forward.
Right, and that was part of our discussion yesterday to defer to you for clarification.
So I put that on my list. Action items.
Is that something that we would probably add to the rules, to the title clarification?
I think to be most clear, yeah, that would be something that we could add to the rules.
Well, my question is, the profession is anxious about this subject because it's gotten to where basically referring to someone who's graduated from architecture school, there's some confusion. If they are an intern, some people think they are still in school, whereas other people know they're not. And it's somewhat confusing, I think, more to the intern than it is to the licensed professional. I believe we all understand what that means. I'm pretty confident I understand what that means. But there is some confusion. So I'm just curious as to how long will this take so we can go back to the registered and non-registered architects of the state and to AIA and whoever needs to know, because this has been an ongoing subject for quite a while, and it's one of those frustrating things where it takes a long time to get a simple answer. And we would like as architects to give some advice on what we can use. It's professional and it's courtesy.
Right. I can get you an official answer before the next meeting. We may not be able to discuss it as a board until the next meeting, but
there will, at least will be on the more of a fast track.
yes.
Okay.
It's on my list of things
All right.
to get back to this committee and the board a final answer of whether or not that complies with the statute, and then moving forward we can add it to a rule, but we can also put publications out from the board saying that it's acceptable if it complies.
Okay. Great. Thank you. That helps me there.
I just like the idea of it in our rules, because we had that policy that was adopted in the late 90s that most people didn't even know existed.
Right.
Policies, those things kind of get buried and lost over time.
Mm-hmm.
If it's in a rule, it's there for everybody to read.
Yeah.
It makes it clear. But but in the interim, until that's adopted, if legal says, hey, that term's okay, it doesn't violate the statute, then we can certainly make that known.
Okay, that's all I'm asking.
Right, and then if it does, if you do move forward with adding it to the rules, we do send electronic notifies out periodically through the rulemaking process to all the licensees that are signed up for that. A lot of people don't read them, but my email is on there for questions and concerns throughout the rulemaking process.
Okay, thank you.
Is
that it? I'm sorry.
Have a question?
Are you finished with your report?
Well, there was one motion that your committee made that you you did mention about pursuing legislation to define the practice of architecture.
Yes, but I was going to defer that.
Okay, okay.
I wanted to, because I didn't want to go over it twice.
Okay, I got
Is that?
Yeah, that's fine.
Okay?
Yeah, that's fine.
Okay, all right. That's the end of my report.
Is the engineer intern, is that a rule, a law, or a policy?
That's in the
It's
law.
in the statute
Yeah.
right now. If it does not comply with the statute after I review this with my supervisors, and it's something that you would want to look into a legislative change, you can look into that as well, but that might be a little bit longer of a process. It's just, it's not something that I can give you a yes or no on right now without consulting them, since it's going to affect all of the entities.
Any other discussion? We will move on to the engineering committee report.
Okay, engineering committee met yesterday. We reviewed applications for comedy in the exam, and we interviewed 2 applicants. We went over potential law, rule, and policy changes. One was, we discussed having a definition of engineering, and the committee wants to get the viewpoint from legal on before we consider that further. Comments and general viewpoint. The other item under law and rule changes, the engineering committee, and this grew out of both dealing with the applicants as well as the research that had been done about progressive experience obtained, our rules about that and policies. The engineer committee recommends a rule change for the board's consideration to grant progressive experience obtained prior to the qualifying degree at a 3-to-1 ratio with a maximum of 1 year granted. So that, I don't know whether that waits for the laws and rules committee report or whether that's something that requires a board vote. Anyway, that's I guess a motion that came out of the engineering committee.
I think since you know already that you want to pursue the rule change, if you make a motion for the entire board to vote on the legal draft, the rule change for you, and you can vote on the completed draft at the next meeting.
I make a motion that we adopt the recommendation from the engineering committee to allow experience prior to the attainment of a degree, progressive engineering experience prior to the attainment of a degree at a 3 years of experience to 1 year. It's 3-to-1 ratio of experience with a maximum of 1 year allowed.
I'll second that.
We have a motion and a second on the table. Any other discussion? There being no discussion, all in favor say aye.
Aye.
Aye. Opposed? Motion carries.
Okay, then we assigned some observers for ABET accreditation visits that will happen this month. Philip Lim will go to UT Knoxville, and I will go to Union University to observe that. We talked about the application reference form, and the committee is going to continue to review the form to develop improvements. And the plan of action is that we will suggest changes prior to the December meeting for consideration. Hopefully we'll have something to look at in December. electronic seals and signatures. We continue to monitor that topic, and in particular TDOT as they're looking into using digital signatures. And on decoupling, we continue to monitor the professional society's evaluation of decoupling. The end of that report.
Is that the extent of your report?
It is.
Okay.
More.
No. Thank you, Ricky. The next is the Continuing Education Committee report. I guess that's me. Good portion of what our discussion was in the Continuing Education group or committee meeting had to do with rule making hearing as it pertains to continuing education, and just kind of recap what's in the rulemaking proposal is that for architects, the continuing education requirements would change from requiring, and I'm going to say 7 hours in a year or 13 in 2 years, but for all of those, right now it's that for health, safety, and welfare out of the 24 hours. And we're changing that to all hours would be required to be health, safety, and welfare. Carryover hours would phase out through 2021 or two. I've forgotten exactly. 2021. And then it helps define health, safety, and welfare based on the NCAR model. And then the calendar year option is available. You can either keep working like you are as far as reportings that you use, or you can do it on a calendar year basis.
Up to 2021.
Yes.
Right.
Yes. And then for the engineers, the calendar year option is being offered as being available. They're going to remain, as far as HSW is concerned, there's some debate over what's HFW and what's not, but it still remains 7 hours. And again, I'm saying it per year, even though we do biannual reapplications. And so landscape architects, pretty much the same as engineers. The interior designers, there are no changes. They would still have carryover items. Their manner and availability of CEUs is a little different from what ours are, and they have their same definition of health, safety, and welfare. And there has been verbiage added that pertains to hardship, and I'm just say that generally, but the hardships and makes people that have an avenue to not have to report or have to work with the board, but you have to report to the board, and you can't just say, "Oh, I didn't do them. I had a hardship last year." You have to actually work with the board to get that exemption. Anyway, bringing to the board, we're bringing to the board a recommendation that the board adopt the rulemaking hearing report, and that really doesn't require a second, but that's brought by the committee to the board. So is there any discussion on that, or do I need to?
I didn't know if you wanted to do this in this committee or if you wanted to do it in the Law and Rules Committee, but we need to have a roll call vote of the board to approve the rulemaking hearing, and with that, you'll be essentially approving the draft, and that's the rules that you want to bring to the hearing, and you'll also approve the date of the hearing, which will be the next board meeting on December 7th.
I'll defer
you can do that now, or you can do that during the Law and Rules Committee.
Rick, you're the chair of this Law and Rules.
We can do it in the Law and Rules, but I would like for you to restate that as a motion in the Law and Rules since you discussed it, instead of
reiterating what we just talked about. Or, I mean,
I think we both went over this.
yeah, I mean, I don't want to go. I don't want to.
Yeah, I know both committees discussed it
Yeah.
yesterday. So.
Yeah.
The CE committee made the motion.
I did bring that as a motion.
Oh,
to
you
the
did.
board.
I'm sorry.
Yeah.
Okay.
The committee made the motion.
Right.
Yeah.
So is that okay?
Yeah. Well, I'm sorry. I was reading
Okay.
something. I missed your motion. My fault.
I heard you say that the committee doesn't need a second, but a minute ago, the engineer committee make a motion, we had to have a second.
I don't know if you had to, but you had one.
And if
You don't have to.
If you could add the date to your motion, I think that would just be cleaner as far as the
Okay.
administrative law steps that we need to take for the rulemaking hearing.
And what would that date be?
December 7th.
December 7th,
Okay.
2017.
We would like to add that date to the motion, December the 7th. Thank you. Is there any
Roll call.
discussion?
Roll call
I
vote.
think we do that.
Oh, okay.
It's just a motion.
Does this require a roll call?
Yes.
Okay.
So,
So if Wanda's ready. No, she's ready.
in order to request rulemaking.
Did we have a second?
Okay. Can we have a roll call, please?
Robert Campbell,
Yes.
Philip Lim,
Yes.
Blair Parker,
Yes.
Brian Tibbs, Rick Thompson,
Yes.
Frank Wagster.
Yes.
Kathy Ware.
Yes.
6 votes.
Motion passes. And I have no other report from Continuing Education Committee. So the next one in line is Law and Rules Committee and Policies Committee.
Okay. You got more notes than I can possibly get. All right. Just as a point of order, what we've just covered and made a motion for in the Continuing Education Committee. I don't want to reiterate all that. We're good. Okay, all right, making sure.
Now, I think because we just authorized the rulemaking.
Okay,
that's part
I'm
of
just
the
making
rulemaking.
sure.
I mean, you can just
We didn't-
summarize it for this committee's report if you want, but
I'm-
the board did just hear.
Okay, I'll make a motion to accept their motion. So, all right, how's that? We did discuss that yesterday. We had 2 or 3 other items. One item which was model law definition of the architecture and engineering and landscape architecture, the professions. We had examples of those, I don't remember what pages that was. We had examples, page 6.
I think starting on page 7.
Starting on page 7 in, what section is that?
Model definition.
Model definitions, page
Yeah.
7, if you're interested in looking at that. I'll try to make this as quick as I possibly can. But this is the model language that we discussed yesterday. We felt like, in general, that it was a good explanation of what we do as a profession. Part of our problem was there are no statute references as we have the crossover defending what an architect does and what an engineer does, what's in violation of your respective profession, what's incidental. Can I design a crosswalk? And I'm not a civil engineer. Or can I do a foundation for something that's simple that I'm trained to do? We feel, and I think Robert could talk to this a little more, but we felt like we were either going to be too restrictive or we were going to be too broad, and that's not a good place to be. And I don't know how we arrive at that happy place in the middle there, but I think that's why we were all in agreement that we probably are going to defer some of this back to the legal department for better definitions. Was that on that list as well?
Yes,
I
that
thought
is on
so.
our list.
Well, let me.
And you please expand.
No, I mean, the other
You
thing
don't
is-
interrupt me, yeah.
No, what we're doing is, the definition, it says incidental, and there's some other things in it. But I don't think there's anything in the definitions that say unless the person is competent to perform that. And I think we wanted to add some language along those lines for both professions. So that you didn't have somebody that is competent to perform that gets left out in the cold based strictly on a definition. And that's, so as long as that language gets added and we can review all that total language later on, I think that was the crux of the discussion.
Yeah, and I have notes from all the comments yesterday that you as a board wanted, or as a committee wanted added into our draft definitions. So I'll definitely consider all of those before I present them back to you for the next meeting.
Yeah. And I think we had identified that as architects, NCARB and the state of Alabama actually has a good definition that we like that can be wordsmithed. And so I believe there's just some of that to be done. Alabama. Go Best thing came out of the state of Alabama is an Auburn graduate. That's on the record too.
You raised that.
Yeah, it's recorded.
The battery went dead.
Oh no. Let's see. Now you got me all the discombobulated. That was one item, the definition, and item number 2, I believe, was for the landscape. We talked about the 3-year versus 2-year experience. Would you like to expand on that, or do I need to? Are we glad to summarize?
We discussed, but we actually put it aside and said we're going to leave it alone. But the discussion was simply the state of Tennessee requires 2 years experience under a licensed landscape architect before you're eligible for licensure, whereas the CLARB definition is 3 years. And when you read the CLARB definition, there's another way to look at it, which John raised that question, and so I sort of backed off and said, okay, let's leave it like it is, and the committee agreed to that.
Okay. All right, that was item number 2. Item 3 we just covered. We made a motion to approve the CE rule changes, and so that's been handled. And then we had the last item on the last item on my list, and if I'm not correct, please somebody correct me, was the Q&A from Mr. Cameron, and that's on page 6 on your pad. And Mr. Cameron is with the State Fire Marshal's office, and he had a couple of questions, A and B. If you haven't read those, please just peruse them real quickly. Basically, what the question was in regard to sealing documents, item A, was he wanted to be consistent in that we be required to seal change orders and various addenda and field changes. We discussed that. I think Robert hit it right on the head. We all agreed. If it actually impacts the design intent, that is something that we need to consider sealing. But if it's a directive or a piece of correspondence or anything to that nature, it's not really something that we need to seal. But if it's a document that does that, then we don't have a problem with it. Or Robert, did you say we should or we?
Oh, you're exactly right. If it's the design intent, we need to seal it.
Okay, all right. So that was where we were on it. Go ahead, Rick.
Okay, and I read that and I understand. I think for a rule change, the wording needs to be request for change order and not change order, since change order is a document that the contractor produces. And
Right.
we can't stand for that.
No.
request for change to the scope of work, the design, that's where I think the profession needs to restamp it.
Yeah. But we weren't making a recommendation that we accepted as it is. We were making a report to you that we agreed in principle
Yes.
with the intent of the design as it changes. We
Yes.
should respond professionally to that.
Yes, if the design professional produces either a change design or direction that changes design, that's what they stamp.
Yes.
Yes.
Yes. And that's where we wound up with it yesterday. So.
Well, now, let me ask you this, because I think I heard you say that you wouldn't seal the change order, you'd seal the request for a change order.
Well, the request for change order is something that a design professional authors.
But that may not come to pass.
May not.
The change order is the legal document.
Well,
That's what needs to be signed.
I was really looking at this word. You're probably right. It should, maybe change order needs to come out of there totally. But a change order is the contractual document between the owner and the contractor.
Right, but it's signed by the architect.
Yeah.
Signed. Is it?
By the owner, the contractor, and the architect. All three.
Do you seal that?
Yes. And if there's any, like, supplemental drawings attached to that, you seal those.
I
drawings
understand
also.
about the supplemental drawings.
Right. But yes. And same thing with addenda, which during the bid process that's pre bid document.
That's understood, yeah.
Those, and then, again, I hate to use an architectural term, but ASI, which is Architectural Supplemental Instruction, is it's a non-monetary direction to change, but that should be sealed also. Now, if there's an engineering version of a similar document, I'm not sure I know what it is.
So
But the document that between the owner, the contractor, and it's approved or agreed upon by the architect, that needs to be sealed.
I guess that's more like I reviewed this and found it to be acceptable, not that, because you did not come up with the dollar numbers.
That's right.
You didn't author the information in there. It's simply for review.
Well, in a way, I would author it in that, let's say we're going to take something out of the project. That normally would follow a request for proposal from the contractor, which he would respond with what he would charge to take it out or add it or whatever, and then that becomes a part of the document.
Yeah.
But it's normally instigated by it is instigated by the architect, even if the owner comes to the architect and says, I want to take this out, it goes to the architect. Same thing from the contractor.
Yeah, and I understand the direction and the design and stamping all that, but to stamp the change order that has the dollar figures in it, I don't know why the architect's signature is not enough on that. It doesn't. I don't. Do our rules
It's
say
the change, not the dollar figure, really. I mean, there's the ASI has no dollar figure, but it's a change. But that's what
No, I
the
understand
architects-
stamping, again, I understand stamping the ASI.
Right.
The change order is the
It's also a
document-
change.
document that has the accounting in it.
Yeah, but
It does, but it's also it's got two elements.
It's got,
So for instance, if you took out if you had a request to add 3 more motors, that would have some bearing on your design, right? Or if you had a request to take out 3 motors, that would have a bearing on your design. So in the change order, you're verifying those quantities +3 or -3. And I think that may be a little overkill, but I still think that you're you saying, hey, by taking those 3 out, you're not materially impacting what my original design is, or by adding those 3, you're not materially impacting what. That's the way we've kind of always looked at it is, and I know it's got accounting and dollars and all that kind of stuff, but again, as that may be the part that's overkill when you're just saying, hey, I'll give you 30 more days, or I'll give you an extra $100 for this or whatever, but most of those change orders that are done are quantity, what am I trying to say, modifications, which that quantity modification may materially impact, most of the time has some material impact to your design, unless you just screwed up on the quantities.
No, but I equate that, stamping that form to stamping, putting your seal on a submittal review that you do, which that's got as much to do with your design as a change order document, but I don't think people stamp, they don't stamp a submittal review.
Well, you don't seal it, no.
Don't seal it. And to me, reviewing a change order is more like reviewing a
A
submittal.
submittal is a review of something that you have specified.
It is.
And a change order is changing what you've specified.
Well, you've produced a document. To me, you've got design documents, and then you've got a submittal review, and then you have the change design, the revised documents that the change order is based on, and then you have the actual change order document. Anyway, this may not be the greatest place to discuss this.
Yeah,
Maybe
we're getting
it's a
into the
committee
weeds here.
meeting.
Mention that.
Okay.
Well, I think that John would like to make a report back to the State Fire Marshal's office as to kind of a consensus. Right. The wording is not to our satisfaction yet, but I think, could we say we maybe are in general agreement for this?
I think what we talked about yesterday, any document that, in general, any document that changes the design or the design intent needs to have this, and we can disagree about whether a change order does that, a shop drawing review does that, or whatever, but in general, if it changes the design or the design intent, I look at it and say, yeah, it probably does, the change order does, where a shop drawing is my saying that what you're giving us meets the specification, not my design intent necessarily. But I mean, again, we're potato on some of that. Yeah. Okay.
Yeah, I think that'll give the State Fire Marshal's office the information they need.
All right, that was item A. Then there was another item B. Do we need a motion or anything on item A?
I don't think so.
No.
It's just
Okay.
general.
All right, item B on page 6 was about the truss designers. The question was, should they seal their drawings, or should the engineer of record seal their drawings? And there was some confusion about that. And our discussion yesterday, I think we were all in agreement that they should be sealing their own drawings unless those drawings are under the responsible charge of the engineer of record. I mean, it's pretty simple in our opinion. I mean, if you don't agree with that, discuss this.
We agree.
Yeah. So, all right. Was that it, John? Thank you. All right. I believe that's it. That went pretty well. Thank you.
Yeah, to carry that last one a little further.
Yeah.
It should be sealed by the designer, and the designer should be registered in the state of Tennessee.
Oh, yeah, true. You're right. Yeah, because we discussed yesterday, a lot of them are out of state. It's like a metal building. Yeah.
That ends your report?
Yes, sir. I'm
All right,
reported. Thank you.
All right, the next is the Grants to Higher Education Committee, which I got to chair because Susan's not
And
here.
I do have a handout for that. This is the proposed grant distribution.
Okay, well,
I guess we can just pass
I'll
it
pass it
on
on
to
to
these,
you.
or with-
I'm the first person on the totem pole, isn't it? In the morning?
Hey, while we're passing that out.
Yeah, I was just going to get up and go get one of those. But
Ready to pass the cookies around?
But if that would be,
lunch.
Those are Wanda's world famous cookies?
Yes. He's not gonna get it.
Why would you wait till the last day to share?
Wait a minute. What do you mean the good ones?
We'll be here, hey.
Go this way. Come this way.
Well, you got the first hand.
Oh, that's not fair. What is it? A handout is not a cookie.
You got the first handout, I got the first cookie. I heard it.
Yeah.
The ingredients are the same.
God, how did you get it?
Production.
Same number that other people got. We can pass it over to the whole team.
Oh,
What do you wait
oh,
till
another.
after the show?
We're gonna give them 2 each. Huh? All right.
Just encouraging you to come back.
Lunch.
Yeah. Ooh,
You can have a comparison.
Oh, yeah.
that's quite good.
I think that is good. I think everybody now has a copy of the proposed grant distribution. We did meet with the higher education committee, and would like to, and are bringing a motion to the board that this, what you see in front of you, this proposed grant distribution, be approved. And so we have the motion on the table that that you have in front of you is approved, or should be approved. And so
Need a second?
we do not need a second.
All right.
So is there any discussion? There being no discussion, all in favor say aye.
Aye.
Opposed? Motion carries. And that's pretty much the higher education committee meeting. Move on to the finance committee meeting.
I'll make this brief. I believe that John reviewed the majority of the financial aspects of what's happened the last year, the overall spreadsheet and whatever. But by and large, the finances look good. There are what we were looking at today, or what we looked at the committee meeting, was not totally complete in that we have a little more time in there to get information back and so on. So, but the information we're looking at looks good. A couple of items that were that will affect the alternate workstation solutions, the AWS. One of those things that could affect us. There could be some potential reduction of rent, which I believe you rose as something else that could come up. So by and large, everything looks good, and we are having a small staff salary increase. And then all the calls. One thing I found interesting is during this discussion, the calls coming into the board go through the centralized customer service first, and we are charged for that. The board is charged for that to some degree.
Right, that's in our cost base. Right.
So that is something that every year I suppose could be adjusted as well. But anyway, this year everything has worked out well, and next year is looking pretty good too. So that's the report.
Okay, thank you. Moving on, the outreach committee. Steve?
Outreach committee did meet, and I thought we'd last about 5 minutes, but we talked for an hour. I'll go over it very quickly. First item was newsletter article. We had 3 suggestions. There is a article that has been published in the NCWS Exchange in August that we are asking legal to review and determine whether that's appropriate to put in our newsletter. Another suggestion was to ask Blair to write an article about landscape architecture, and also to ask Susan to write an article about interior design, because those 2 parts of our board are a little lesser known, and it might be beneficial to educate our registrants. Also, we talked about publication revisions, and I guess we've been asked to not pursue any at this point in light of the discussion about the QBS FAQ, so we're just putting all those sort of on hold for right now. Outreach activities, we talked about the possibility of maybe doing a couple of seminars a year for new registrants to help indoctrinate them into what the board does, and kind of help get them off to a new start. We also talked about inviting new registrants to board meetings, and we also continue to offer to go to schools to promote licensure. Last item is meeting with the deans, and we plan to do that again next October at our at the board retreat at a undetermined location at this point.
State Park. We're not sure which one.
Someone suggested Gatlinburg.
Can I ask you a question? Am I going to be chairman this meeting next year?
You want to be? Depends on how the board.
I don't know.
Depends on how you act.
Well, I didn't know if that was automatic. Am I vice chairman?
Are you campaigning?
It's not automatic.
Yeah.
Okay, well, I didn't know if it's automatic.
It's not automatic.
Y'all know this, it's not automatic.
Yeah, that's fine. I just didn't know.
You got any of those extra shirts, maybe?
I don't even have it.
What did I tell you?
Sound like you're campaigning.
What did I tell you? No, I just said, because if I'm going to be the chairman, I'm going to push it. We got to get it.
That's
Well,
not a
I think
state
that
park.
From an administrative
Yeah,
perspective, it might be a hard sell doing that.
I think
The state park would be a lot
I
easier.
don't think so because the department.
For your help, Liz.
Wait a minute, I thought Gatlinburg is the national state park, right?
Well, I'm just saying
Smoky
with
Mountain.
the department's recent involvement after the Gatlinburg fire with the insurance division and contractors board, I think that the department would look favorably upon that. That's just my personal opinion, though that has not been consulted with
Hey, John,
any of the decision makers.
last time I checked, the Gatlinburg Smoky is the national state board, national state park, so we know the park.
The Ashbury State Board.
True. They're actually,
Yeah,
is it
national.
Roan Mountain State Park in that area?
San Juan.
Yeah.
Roan Mountain, there's a state park in that area.
Tennessee
That's in Elizabeth, but
professionals
that's
working
close
down there.
enough. There's a few state parks up here.
I got
I just can't.
All right, I didn't know. Sorry.
Hey, if the board do any outreach program, I think we ought to be able to promote that and continuing education, giving continuing education. The outreach committee is gonna bring the new registered to come in and welcome them. And I would think it'd be one of the part of the things you might do, spend some time talking about laws and the rules, you know.
We talked about that, and it would, we think it would be eligible for
I think so.
continuing education.
I'll be glad to conduct it.
It's an outside consultant.
That's why I think it'd be a good way to kind of welcome them and, you know, maybe go to NCWS, give them a t-shirt.
Sure.
Mr. Campbell can take it.
Mr. Campbell, give us a t-shirt. Thank you.
We didn't have any items.
Makes the board vote
motion,
again.
but that would conclude.
Okay. All right, thank you. And the last item on our agenda is general discussion of future plans. I think we're,
That's our catch-all in case we
Yeah.
forgot something.
I think we're planning on meeting in December.
So I have one general plan and discussion. I've asked Kathy Ware and Alfred Hitchcock, right? Is that his name?
Yes.
Alton, since they are our Nashville people, to get together what our annual Christmas theme is going to be. She's begrudgingly accepted.
But only if Alton washes the dishes.
Only if Alton washes the dishes. That'll be fine. Alton will wash the dishes. I'll make sure he does. But I just think it's much easier with them being in Nashville to kind of help plan a location like we did, have done several years for our staff appreciation thing and all that stuff. So, but you may or may not have your kneecap breaker. We don't know what your status still is. So as far as money, so we'll talk about that a little bit more as we get closer to that time.
The last time they would have paid $50. It's been consistent, $50 has been consistent.
Yeah.
Does Kathy still get the coffee?
She busts the tape.
I have one question in regard to that. Is that a scheduled luncheon for Kathy, just for her benefit?
Do we have a deadline for registration?
Yes, we do.
You don't have to take this abuse.
We're getting tired. We're tired.
You know, it just means that y'all love me. That's what my mother used to say when we picked on her. It just means that you love me.
If we have no other business, entertain a motion to adjourn. Oh, we
no,
got
if I never come back again to see you.
Bye, good to see you.
I'll be back. You'll be back.
You'll have to go back to get your certificate.
Yeah.
Really,
Again,
this
this
is-
certificate.
I need to be back and get the rest of yours. I will probably come back and join you for lunch.
Yeah, Bill,
because I like to participate.
Please do.
Please do, yeah.
All right, I make a motion that we adjourn. So moved. All in favor? I'm sorry, Mr. Chairman, I don't mean to get ahead of myself, but
We are adjourned.
I'm running against Robert here.